Okay, I think we should start. It's 5 minutes past 9 o'clock. And as requested, that we defer by 5 minutes. We are on the dot. Good morning, everyone, ladies and gents, colleagues. Welcome back. This is just a continuation of what we started with yesterday. So thank you very much for turning back. I'm picking up an echo. Hopefully then, as we start today, all of you who are here, you were with us yesterday. Just in case not, I hope that with the first 5-10 minutes, Graham might also assist us as a facilitator to just recap in the event that one or two of people that are here this morning were not with us yesterday. Yeah, I don't have any much to say except that we have deliberately withheld any issue of or distribution of handouts precisely because I just wanted for us to build up. Because other than just the guide and the presentation, from yesterday's delivery, I also had picked up that there are a few other supporting documents or additional documents that we might to add to that pack. So let's see what comes out today. I think this will then give us a sense of the full pack of handouts that would be distributed to everyone. On that score, let me then hand over to Graham. Are you sorted on your side, sir?
Yeah, already.
Cool.
Already. Yeah, so morning everyone. I hope everybody from yesterday has come back. Let's see, yeah, the names are looking familiar. Avi, I see you back. Umzile, you back, just the screen that I'm looking at, I can see, yeah. Carisha is back, Ricardo is back. I think that should be Johannes. This is Jahan D. Molefi. So I don't know if that's a spelling mistake. So welcome back to all of you. John, I think it's a good thing that people have come back.
Certainly is.
If they didn't come back, then we know there's a problem.
Yeah.
Right, guys. So let's have a look. We're going to obviously carry on from yesterday. So where we stopped was at the end of section 6. So with complaints management, what we're going to do today is we're going to discuss complaints management, then conflict and dispute resolution, then the tenant satisfaction survey and tenant exit. And then you'll see I'm going to spend quite a bit of time talking about the Rental Housing Act, because the Rental Housing Act is really one of the important pieces of legislation that, as a landlord, you need to be in compliance with. And you'll see that the Rental Housing Act creates protection for both the landlord and the tenant. So in that respect, it's a fairly balanced piece of legislation. Obviously, the challenge is that where you have a tenant that is in occupation, it's of course an advantage for the tenant, because I'm sure you've heard the saying that says possession is 9/10 of the law. So I'll deal with that, with the non-payment of rental as well, what your options are with regards to the non-payment of rental. So some of the issues that we spoke about yesterday. So Carisha, after yesterday's session, you guys, you've decided you're still carrying on? You're not running away? Carisha, you with us? Maybe not, John. I thought some of the people after yesterday's session would think they're going to run away. So yeah, as I said, it's very nice to see that you are all back.
Yes, we are back.
Good. Right, so let's talk about complaints management. You remember, guys, that obviously what we spoke about yesterday is the fact that we really need to view this as a partnership with the tenant. So, it's not that we're in charge because we're the landlord. The tenant obviously has certain rights, and we want to have a successful development. And to have a successful development, what's required is that we need to ensure that the tenants are in fact our partners. Of course, if there are dissatisfactions, then tenants need to be in a position where they are able to complain. Obviously, we need to also be able to understand the seriousness of the complaint. So is it a complaint that's frivolous, or is it something that is fairly significant? And also, again, following on from what we discussed yesterday, if you've got open channels of communication with your tenants, your complaints will very often be more suggestions that are made through your communication channel, as opposed to people who are angry and upset because certain things are not happening, certain things are not being done. So that's why it's important to have these open channels of communication that happen on a regular basis. So not that you only talk to one another when there's an issue that needs to be addressed, but more so that there's, regular monthly, every second month, bi-monthly or quarterly communication that takes place. If you look at the second bullet point, so the complaints would be made either in person or through a complainant's representative or their advocate, so somebody who's acting on their behalf. You might find that you are dealing with people who, let's say, are illiterate, so they can't actually write their thoughts down because they're not able to, so they would have somebody who represents them. You'll see that I've made the point as well to say in some cases a complaint can be made anonymously. That obviously can be problematic for you because you'd like to know that somebody is not just being a troublemaker, but you actually know who the person is and what the nature of the complaint is and what it relates to. So you'll see in the last bullet point I've said that we would look at a specific occurrence or circumstance and the impact that has had. So we normally find that there are 4 categories that a complaint falls into. So number 1, it would be the social housing institution's service delivery. So issues around service delivery, that there are certain things that the social housing institution is not doing. Secondly, the behavior of the staff. And guys, obviously that's why it's very important that you have staff that are properly trained, that understand what social housing is all about, and that have training in all areas. So, for example, things like anger management. You need to obviously be able to address things in a way that's at a suitable level of interaction without getting angry with a tenant, not to take things personally. And one of the areas that one needs to be very careful about is where your staff are involved in any personal relationships with any of the tenants. That may be a family member, because you of course don't want any favoritism to be shown, because it might be a tenant who's a cousin of one of your staff members, or a more personal relationship, and that of course can get out of hand. So, as I say, very important to have your staff correctly trained in that area. Thirdly, would be things like tenancy matters. So this could be antisocial behavior that's very serious, like drugs and alcohol. crime. So you might have people who are living in the development who are involved in this type of antisocial behavior. And of course, it could be at a lower level. So things like noise would be a problem for a lot of people. And then you might also have issues around, let's say, children who are noisy. One's obviously got to strike a balance. You know, we know that dogs bark and kids like to play and make a noise. So we need to be aware of that. You can't have people moaning and complaining and saying, you know, the children that live in number 4 are always very noisy. You know, they're young kids. They may be 6 and 8 years old. So that's what they do. They like to go outside and play. So you've also got to, you know, got to have that education process in place. People need to understand that they're living in a community, and part of that community would be the fact that they have young kids in that community. And then I think one of the most common issues regarding complaints with the social housing institution is maintenance, and the fact that maintenance is not being done. So guys, very, very important that your construction is done correctly, because your construction is going to save you a lot of money down the line in maintenance. So just be aware of cutting corners with regards to construction costs. You'd rather have a better quality of build up front and then save yourself maintenance costs as you go along down the line. So if you don't have the technical knowledge in this regard, oops, sorry about that. If you don't have the technical knowledge in this regard, then it's very important that you have a very good professional team that's able to manage this process for you. You wouldn't know, for example, whether the foundation has been poured correctly, or whether the damp proofing has been put in place correctly, the damp coursing at foundation level. So that's why you need to have a professional team. So just please be aware of that, that the better the build quality, the more money that you're going to save as you go along down the line. John, I think there was a hand. Is there a hand somewhere? No, it looks like that person's put their hand down. Okay, I thought there was a hand up. Okay. Right, so guys, the tenant complaints management system would be based upon the following principles. So number 1 is tenant entitlement. So we need to accept that tenants are entitled to complain. So we can't take the view that, oh, well, you know, you're paying a lower rental, so you're not allowed to complain. We are still taking money from that person. They are still a customer of ours. And remember that our social housing development is designed to achieve certain objectives. And one of those is to provide housing for certain members of society. Responsibility. So that's the social housing institution accepting that it is responsible. It is a responsible institution and it takes complaints seriously. Accessibility. The idea here is that the social housing institution must be accessible. You need to be accessible to your tenants. That means that the tenants need to be aware of what they do if they need to complain. So that's the issue of awareness. And it needs to be accessible to them. So you can't make it, you know, difficult to say, well, your complaint needs to be in writing and it needs to be delivered to a specific address. And you're making it as hard as possible for the tenant to be able to submit any complaint, any genuine complaint, obviously, that they may have. Then number 4 is responsiveness. So what that then means is that once you receive the complaint, then you need to do something about it. So you can't just say, yes, fine, noted. My general experience, and, you know, guys, I can tell you, I've come from a legal background and I have done quite a number of mediations and arbitrations in disputes. So I don't know, 40, 50, 60 over the years. I can't remember how many. And very often what I find is that you resolve a lot of issues when people have somebody to talk to. So when you have a situation where people don't have somebody to talk to and nobody's listening to them, that's when things start to get out of hand. So that's when you find that temperatures start to rise. People get very upset because nobody's listening to them. So one of the most important things is that you need to actually have a system that allows people to complain, and then you do something about it. So you make sure that people have been heard and that there is some response. Of course, guys, we're not talking about those complaints that are frivolous, okay, where people are just trying to create nonsense. So it needs to be efficient. That means that you need to obviously respond timeously, and you can't just leave it. And you also need to be, as far as the efficiency component is concerned, you also need to be respectful of the complaint. So would certainly not be suitable to go back to a tenant and say to a tenant, stop talking nonsense. Okay, there's nothing wrong and you're just creating trouble with everybody. So there are ways of doing it, and it needs to be done in a timeous and respectful manner. Of course, the system needs to be fair. So as I've mentioned already, we need to be impartial. You can't have, let's say, as I've mentioned before, a family member living in the scheme and they are showed some kind of favoritism. It needs to be confidential. So you can't be, let's say, as the supervisor or the property manager on site, telling all the other tenants about the person in number 10 that's been complaining about something. And then the third thing is that it's transparent. So all the tenants need to be aware as to how complaints are managed and what the outcome of these complaints are, especially if it's things that relate to a number of tenants. And then, guys, the principle of integration means that the complaints management system needs to be integrated into your business as a social housing institution. So you need to really welcome any complaints that come away so that they can be addressed. It's very important for your tenants to see that you are addressing the issues that are of daily concern to them. Guys, your complaints management system will generally have 3 stages. You'll see that stage 1 is the screening and registering of a complaint. So you would receive the complaint, you would see what the issue is, and perhaps it's something minor that can be dealt with very easily and simply. And in such an instance, then you've resolved the complaint. Where you just ignore it at the stage 1 level, that's when things start to get out of hand, because then tenants then start to obviously get very upset. Stage 2, if the tenant is still dissatisfied, then you might need to escalate the matter to a higher level. So stage 1 might, for example, be dealt with by a caretaker or supervisor or property manager on site, whereas with stage 2, you might need more higher level management intervention in order to address the issue. And then the third stage, so this is going to be where the social housing institution is in a position where they're not able to handle the matter internally. And what they might need to do is look for external assistance in order to help. You'll see a little bit later on, I'll talk about dispute resolution and some of the options available with regard to dispute resolution. And then that's where you might need to get a third party involved, like let's say, for example, a mediator to come in and try and assist to resolve the dispute. So you'll obviously have a system in place, and you'll then decide, how serious is the matter? How do you filter the various complaints? How can they be managed? And you really just want to get to a situation where you don't have the dispute getting out of hand. Then it lands up in the press. You might find yourself in a situation where you land up at the Rental Housing Tribunal, and you really didn't need to, because if it had been addressed at source at the beginning of everything happening, then you would have been in a situation where it would have been resolved and it doesn't get out of hand. So just some more detail around the complaints management system. So you can see the steps, as I've mentioned. So step number 1 would be the registration of the complaint. So this will either be in person or in writing. Today via email would normally be the case. Unlikely somebody's going to be writing you a letter. You would then assess the complaint, so that somebody would then be in a position where they would actually look at the complaint and see how it can be addressed. Of course, if it's a serious issue like criminal behavior, so things like drugs and alcohol, it might be necessary to actually report the matter to the police and then hand the matter over to the police and let the police manage that complaint. As I said, there could be some criminality that's involved. You will, of course, get complaints that are trivial or frivolous. And you can see, if you look at the bullet points, you can see the types of things that would be really trivial. And you obviously need to be able to address these as well. So things like a complaint that's based on a false statement of fact. So maybe hearsay, somebody really hasn't investigated what's happened. They've just been told something by a neighbor, and it's actually a false statement of fact. Constant complaints by a person who does not have sufficient direct interest in a matter. So, there again, you don't want people complaining if it's got nothing to do with them. They need to stick to their own lane and their own business. Constant complaints against one tenant or a service provider. And that's obviously where it's not based on fact. So it's not true. And it's just these complaints that are made because there might be somebody having an axe to grind against a particular service provider. Seeking to revisit the same issue after initial investigation. So this would be where maybe things are not resolved entirely satisfactorily to the tenant, and they just want to go on and on about the same thing. Making repetitive complaints and then withdrawing them. So obviously, it's not a serious issue, because why do they then keep on doing that? Using complaints about another person in order to divert attention away from a particular person's situation. So, for example, I'm not paying rent because my neighbor next door makes a lot of noise. You can't use that as your excuse for not paying rental. You need to pay the rental, and then as the social housing institution, you need to address the issue of the neighbor next door that's making a nuisance. Unwillingness by the complainant to cooperate with the social housing institution to resolve the complaint. So, one of the examples may be that there is an issue with a neighbor, and that as the social housing institution, what you want to do is you want to relocate that tenant to another unit in the development. And the tenant then says, sorry, I'm not moving. I'm very comfortable where I am. I'm not going to pack up. So then the complainant needs to be willing to work with you to resolve the dispute. And then making ongoing complaints, obviously, about something which is considered to be trivial. So this needs to be addressed as well. Obviously, what you would need to do is manage the situation, again, in a respectful manner, to explain that it's not something that needs to be addressed because it is of a trivial or frivolous nature. Thirdly, to take action. So again, as I've mentioned, you need to be efficient in this. So there needs to be speedy resolution. You don't want the matter hanging around. And depending on your staffing setup, so whatever the structure of your staffing is, you may have a client liaison officer, a client services manager. So whoever's going to deal with the complaint, then it needs to be sent on to that person to manage. Outcome. So obviously you need to achieve an outcome. There needs to be an end result of all of this. And what's important as well, ladies and gents, is that you actually prioritize the documenting of what has happened. So it's very, very important that you document the complaint, you document what has been done, and you document the outcome, and that is then given to the complainant. Because you also don't want to have a situation where these things are not documented, and it's one of the reasons why your tenant then goes to the Rental Housing Tribunal. So please document everything and provide a copy of that to the person who has made the complaint. And then, of course, the fact that a complaint has been made might mean that you need to make some changes. So you'd need to monitor what has happened. You might decide to change some of your systems, to change the way that you're doing things, to perhaps improve some of your business processes and methods. And the complaint might have actually highlighted and drawn your attention to something that in fact needed to be attended to. So that's why, as I said to you earlier, it's very important that your complaints management system is integrated into the way in which you do business. John, anything that you want to add there about the complaints management system and handling and addressing complaints? Any suggestions that you want to make to the delegates? No, all good. John's happy with that. Guys, any questions that you have? Let's see what we've got in the chat box. Right, everybody's just saying good morning, and Motapi. So you've asked John that the documents and manual have not been received. If you weren't here at the beginning of the session, John did mention that there are some other documents that he wants to include in what will be sent out to you. So you will get all of the documents. So that will happen in due course. John's going to then obviously put all of that together for you and dispatch it to you. So Motapi, that's not because there's been a problem with your email or something. So John will send that in due course. So management will be responsible for developing and reviewing the complaints management policy and procedures and systems, ensuring that there's adequate and competent staffing to deal with complaints. You need to have people who know what they're doing. And you really should also have a relationship with the Rental Housing Tribunal to support this whole process. So you'll see that's what I'm going to do towards the end of our session. So I'm going to talk to you about the Rental Housing Act and the Rental Housing Tribunal. Staff will be responsible for providing awareness and education around the complaints management system. And again, guys, as I mentioned to you earlier, your communication system and the ongoing education that you have should actually reduce the need for complaints. You may remember, as John mentioned yesterday, one of the most important things is, as the owner of the development, you need to be present. So you cannot be an absent landlord. And if you're present landlord and you're involved in communicating with your tenants on a regular basis, you should very well find that the incidence of complaints will be far less than if you are an absent landlord and you just display this attitude of couldn't care less. Staff would also support tenants in lodging complaints. So, one needs to assist your tenants, need to explain to them what needs to be done, assessing and investigating complaints and providing the necessary reports, communicating with clients, and then the recording of complaints. So also from your perspective, it's very important that complaints are recorded, because you also need to see whether or not complaints are occurring for the same thing. So perhaps there is actually a problem, and that complaints are happening again and again and again for the same issue, because obviously what that will allow you to do is to then address the source of the complaint so that it stops being a complaint, and then you don't have that as an ongoing problem. All right, guys, any questions there?
Well, there is a question on the chat line that you might want to check, Graham.
Right, Tammy's got a problem with his connection. What is the preferred program for accounting purposes? Guys, so there's not necessarily a preferred program. You may have two different types of software. The one would be an accounting software. So the types of things that you would look at, I just want to have a look because some of them are integrated with property management software systems as well. If you just give me a moment. Okay, so guys, the types of software that you can look at. So just from an accounting perspective, there would be things like, I'm going to also put it into the chat box for you. So things like Pastel, which is just straightforward accounting software. From a property management perspective, you can look at things like Xero. So from what I remember, that is that's accounting and property management that are built in together. Then you can also have a look at something called MRI is another one. I know a lot of the property managers use PayProp, and the other one that you can look at is TPN. So Sisi Mokhang's asked, how's the property management software required? So Sisi Mokhang, you would just obviously go online and you can Google it and you'll find all of those details. What you should really do is look for software that's able to integrate your accounting requirements and your property management requirements. So things like generating rental statements, doing activity reports for you, debtors days, checking if debtors are obviously outstanding, and you can then address that instead of doing it manually. Also, just bear in mind that the software comes with licensing fees, so you must just watch out for the costs. You need to have enough units to justify having this type of an automated system. Ricardo, yeah, I think maybe you're having a little bit of a connection problem.
Yesterday, just to catch up on the issue.
Yeah, Ricardo, you seem to be breaking up there. Maybe if you just want to type a few points into the chat box, if you just do it in point form, and then I'll come back and address what it is that you asking.
Okay, that's fine. I'll do it. That's fine.
Okay, as I said,
Yeah,
you sound like you're breaking up there a bit.
No, just on this topic of systems, I think what we've also found to be commonly used as a property and tenant management system broadly in the sector, there's one called MDA that I see a lot of social housing institutions.
Yes, John, thank you. I'm going to put that
use.
into the chat box as well. You're
Yeah.
quite right. Okay,
Yeah.
that is an important one as well.
There's one or two that I've heard, I think, if I'm correct, something called Nico, if I get the name correctly. But broadly, MDA is the one that is broadly used in the sector.
Yeah, Tammy, you've said Zoho as well, but you've also said that you've had challenges with it. So if you have had challenges, then probably not a good idea to be recommending it. Let us proceed. So, of course, as I was saying to you, if we have a complaint and it turns into something more serious, obviously we might now have a dispute that needs to be addressed. So we now move to conflict and dispute resolution. So our dispute resolution system is obviously designed to ensure that we have a way. Sorry.
Sorry, before you go on, Graham, I see that Ricardo has put up a question on the chat. Hi guys, I just wanted to find out if the SHRA gets involved in complaints management if it reaches critical stages, as tenants views this is government development funding. So yeah, you asked a very important question, Ricardo. In the main, disputes that relates to the tenant and the landlord in their nature would be referred to the rental tribunal, which I guess later on Graham will touch on. So within the SHRA, there isn't that, in fact, within our mandate, there isn't that responsibility or capability even to deal with tenant landlord complaints and disputes. However, there are cases where it is service delivery related and somewhat also has to do with issues of where there's total breakdown of relationships. There again, the SHRA would come in, particularly when such issues starts to affect the compliance and the sustainability of the institution. Because bear in mind, amongst other things that we are tasked with as a regulator, is to monitor on regular basis the compliance and the viability, I mean the sustainability of the sector. So there are cases where SHRA gets involved where there is an observation that issues that are being raised or that are at play on the ground have that bearing on compliance and sustainability of reporting institutions. I hope that helps.
John, do you maybe just because perhaps people are not entirely aware, do you maybe just want to spend a minute or two just at a broad level explaining to people what SHRA does and what SHRA doesn't do?
So we're one of the oddly set up regulator because on one hand, as the name suggests, in the main, we are a regulator of a program, social housing. We are one of the entities of the Department of Human Settlement. Those of you would know that there are a couple of entities under the Department of Human Settlements, and SHRA is but one of them. I mean, NHFC, which is the National Housing Finance Corporation, they in the main are your bank in the sector. There's HDA, Housing Development Agency, which is responsible for supporting government, mostly provinces and municipalities, with issues of land banking, land release, and so forth, for a whole range of human settlement programs, not only social housing. There are others like NHBRC and so in terms of the SHRA, our mandate is actually threefold. So on one hand, we are responsible for regulation, and the regulation function, in the main three core functions that we do. Within the regulations, there's accreditation. So any projects or any institutions or delivery partner that we would partner with to deliver social housing would have to be accredited, or a project would have to be accredited. So that's the first part where we accredit social housing institutions and projects, and there's a whole set of criteria there. Still under regulations, colleagues, there's also a function of compliance and monitoring, where now on quarterly basis, the institutions that have been accredited and those institutions already have stock under management. In other words, they have a property and that property is tenanted. There's a requirement according to the Social Housing Act that and regulations rather, that those such an institution would then have to report to the SHRA on quarterly basis. So that's another function there where through this monitoring and through this regular reporting, we're then able to assess and monitor the compliance status and the sustainability status of each reporting institution. It's a big one and hasn't been one of the strongest, I must also be honest, one of the strongest function, but there are plans to strengthen that side of the business. Again, still within the regulations, there is that regulatory function which in the main looks at intervening at projects and institutions that are in distress. And this is where we would come in and put an institution under administration. And that essentially says you set aside the board and you put in an administrator to manage the affairs. There have been a few projects or institutions that have had to be unfortunately put under administration. It's all regulated in the Social Housing Act and the regulations. So that's the first side of the business, is this regulatory function. The second one, which, as I said, it's one of the oddest one in terms of how we're set up as a regulator. We are also an investor, because part of what we do is we are responsible for administering grant monies. Grant monies in two sense. One, there is that capital consolidated capital grant, or CCG as we call it. That 426 that we spoke about yesterday. So that would be then another function of the SHRA in terms of, assessing potential projects that are submitted as social housing projects, and after that assessment, as identifying that these are bankable, would then facilitate those projects to be approved for this capital investment. Part of the investment as well, that's where I sit, has to do largely with support interventions, wherein we do, for example, training sessions such as this one, the research work that we do in the sector, and any other interventions. For example, if a reporting institution or project is struggling with performing against certain benchmarks, for example, collection of rental revenue, we're then able to deploy not the capital grant, but the intervention support grants. One of which I mentioned yesterday, the staff gear up grant. Those of you who were here, you would remember that amongst other support grants that we administer, there is that staff gear up grant, but there are whole of other support grants. In fact, in total, there's a basket of 5 types of support grants. So one of the 5 support grants that we administer would then be used to intervene and support an institution or a project where we are picking up through compliance and monitoring that this project or this institution is not performing according to the required standards. All that is, so I just really try to summarize a 2-day training, because there's a whole 2-day training that we do that covers really the functions of the SHRA, that introduction to social housing. I hope that some of you may have enlisted for that one as well. So it will be one of those trainings that we offer in this financial year. Yeah, I think so. The long and short of the mandate of the SHRA and what is it that we actually do.
All right, guys, any questions that you may want to ask John? John, let's have a look at questions in the chat box. So I think you've answered Ricardo's question about the getting involved in complaints. Koketso says, are we going to have physical lessons, or are we only having remote lessons? So John, maybe you want to just talk about that, if that's the case, or we're going straight into practical or starting with the theory. John, perhaps what Koketso needs to have a look at is the training program that you have on becoming accredited. So what you need to do to become accredited.
Correct. And part of what I guess Koketso is asking, from understanding, boils down to the nature in which we have structured these trainings this year. Many of you will be aware that there was an instruction from Treasury sent through all the government departments, including entities, on cost containment. Ordinarily, a training program, we have it as physical contact sessions where, it allows us to have all sorts of role plays and things like that. Now, because of that instruction, we are restricted to this online or carrying these things online. Comes with, some benefits, but also there are those limitations. But Graham is correct. Some of the topics that we would be running in the training program this year, including, for example, SHI accreditation, would also bring in the practical element to how one would package an application for you to be accredited as a social housing institution. Topics such as project packaging, for those of you who says they have a potential project that they want to, that training, it has elements of practicality and application as well. So consider enlisting yourself for those. I hope that helps, Koketso. Was it Koketso? Ne?
It was yes, it was Koketso. John, can I maybe just add something there as well? Is that I think it's very important for people to understand that accessing something like the capital grant it's not a get rich quick scheme. If one's going to go into the social housing environment, you've got to be really serious about your commitment to social housing. So this is not, it's not a way of accessing that 426,000 per unit, getting the government to fund a significant portion of your construction costs. You try and make as much money as possible and then you disappear. So it's really about your commitment to the process. And guys, as John has indicated, obviously the first two important functions that John highlighted, which I wrote down for you, we can just perhaps just show you that again. So I've written it down here for you on the screen, is accreditation and compliance and monitoring. So obviously SHRA wants to know that they're walking the road with a committed partner, that they're not, they're not operating with people who are just looking to try and make as much money as possible and disappear. And so I think that to go back to the type of question that Koketso is asking, it's very, very important that you attend the training session on accreditation and how to become accredited and the process that needs to be followed. John, let's see what other questions we've got. So Boitumelo says, to go back a bit, would an in-house developed software system be considered eligible to be used? Boitumelo, definitely. You could develop your own in-house system. Just be aware that developing your own system is often very, very, very costly. And you also need to be aware that a developer will quote you a particular price. So, you might be quoted, let's say, a price of 200,000, and before you look around, you've spent 800,000. My suggestion would be to get the software that's already been developed. The cost has already been incurred, and you pay a licensing fee. Tammy says, I understand that you're saying we are landlords. We need to be hands-on. However, can I outsource the management? So, Tammy, of course, you could have outsourced management. But your problem is that by having outsourced management, you don't have your own boots on the ground on a daily basis that know what's going on. So if you are going to use outsourced management, you've got to make sure that that outsourced management is effectively communicating with you and is able to provide you with the relevant information on a daily basis as to what's happening. My suggestion would be not to have outsourced management. It's far better that you have your own in-house management, because also, your own staff are going to care about the business more so than an outsourced manager. So that would be my suggestion. John, what are your feelings about in-source versus outsourced management?
Yeah, so I think we dealt with a question similar to this yesterday. So if you are an SHI, Tammy, I think it is expected that this property and tenant management function is one of your core functions. In fact, you are not necessarily a developer, but more of a property and tenant management agency. So as we said yesterday, it is good practice that we've seen in especially with newcomers, where in they're developing their first project to then look at an outsourced model, but with a plan to build in that capacity in-house. So you identify a property and tenant management agency, and you get into an arrangement that says there must then be a skills transfer plan or capacitation plan over a period of, let's say, 2 years, because that kind of capability needs to be in-house. It goes to a number of things that, as Graham touched on. On regular basis, you must report on performance. Your board must know what is happening on a whole range of things that pertains to the business. And if it's an outsourced function, there's always a risk that because you don't have those boots on the ground, certain things you are almost, because you're using a middleman approach, you might miss. So quite critical that as an SHI, you have that mentality. However, I must also qualify this that other delivery agents, which are your private developers, in how we've considered, or the SHRA has considered grant funding for such projects that are brought in by private developers, we have accepted that someone brings in onto the table a development capacity, but they're not necessarily a property and tenant management expert. In that arrangement, I think when an applicant applies for a project, SHRA wants to make sure that there is a managing partner who would then carry the long-term management of stock and tenants as well. So it's not necessarily an outsourced function in that arrangement, but it's more of a partnership arrangement where when your project comes in, you are a private developer. SHRA wants to make sure that, okay, you're not only showing evidence that you can and have the capability to develop this thing from construction to handover, but you have a partner that can actually carry out the property management and tenant management functions. So it's a two-prong approach that you can consider. Either as an SHI, where, as I said, those are core functions that must be in the organization. If you are coming in as an ODA, that's a slightly different arrangement where you look at who's capable out in the market and you bring them in as a managing partner. Hope that helps.
Yeah, and John, I think that both you and I have made the same point, is that if you're using outsourced management, you just don't have a handle on what's going on in the development. So you really need to, and just remember, Tammy, that's when things start to get away from you, and that's when you start to have your rent boycotts and the problems that you're going to land up with. So you want to just be very careful about being in a situation where you're outsourcing everything and you're not actively involved in managing the development in your tenants. Phumzile?
Graham, thanks. Morning, everyone. No, John has clarified or answered my question. I was going to ask the whole issue about if you partner with another company at submission phase, is that allowed? Is that something that they will be frowned upon? But it's cleared that up. So thank you for that. I've got my answers.
Okay, good. Tammy, have you got another question, or does it relate to your issue of outsourcing of management? Your hand is up. Right, so I assume we've answered your question for you. Okay, guys, so let's carry on with conflict and dispute resolution.
There's just a few more questions on the chat.
Sorry, John. Okay.
See
how many training? So John, this one you'll need to answer. How many training programs of SHRA must be attended for one to be fully accredited. That's Exodus. So, John, if I can maybe just say, I think that you've mentioned quite clearly that there's a whole accreditation process that one needs to go through, and that's why it's important that people attend the training that you run on accreditation. John, I don't know if you want to add anything more there.
No, certainly. So I think Exodus, make time to enlist for that one. It's similar to this in terms of structure. It's a 2-day online, and we will then be zooming into the entire application process. What documents are required? How do you construct those documents? And I guess it also, as part of the handouts, gives you access to some of the templates so that you don't reinvent the wheel. It's not necessarily about attending a certain number of trainings for you to be accredited. Just let's also clarify that. I think one, I'm trying to understand the question or read between the lines in terms of what you're asking. One is important that one attends trainings, but trainings is not a solution to everything. Quite important is you need to explore all sorts of avenues to improve and build up your understanding of the program if you are going to be a player in the sector. Training is but one of those solutions. Specific to the accreditation, in fact, what we've always recommended is once you have attended the training, because there is a process owner that manages the SHI accreditation process, just like there are process owners for various work streams like project accreditation. Once we have done the training, and remember, the training is really projecting things on a more generic and broad thing. You then would be, and this is a recommendation that we always do, that post the training, now that you have that broad understanding, make contact and build that relationship with a process owner so that they can handhold you in terms of you now physically completing that application, SHI application and submitting. So they'll be able to guide you far beyond what we are able to do over a 2-day session such as this one. I hope that helps, Exodus.
Yeah, right.
question
Then next one, I think, John, is Motapi. Does the SHA assist SHAs in the process of getting municipalities to declare restructuring zones to enable the development of social housing, where there is a need, like the Hartbeespoort Dam area, and like dealing with the local authority out there?
So within the SHRA's mandate, definitely this is not an area that we go into. However, because remember, within the human settlement, there is a whole value chain of stakeholders that are at play. And when we talked about, in fact, the gazetting of the restructuring zone, I did indicate yesterday that the process requires that the municipality must first, designate an area for gazetting, and the council in that municipality must take a resolution assisted by the province, which is the next stakeholder. They then would put together an application between themselves and the municipality. That application goes straight through to the National Department. There's a directorate at the National Department that is responsible for processing those applications. And they would also, if need be, can come to the municipal level, meet with officials and explain that whole application process in terms of how is an area demarcated to be a restructuring zone and what is the process. That is the contact that we can facilitate. If Mdape, you have a specific need and specific people that you think we can put you guys in contact with, that kind of engagement we can facilitate, because there are colleagues in the National Department that are responsible for that we work with on regular basis. But as the SHRA, it's not a process that we would drive from A to Z. Hope that helps.
So, John, I think that's it. I think those are the questions in the chat box. Tobalani, your hand is up.
Quick one, Graham and John. When is the next project packaging program or course? Because I see there was one in February, if I'm not mistaken, here on your website. When's the next one?
Yeah, so you caught me there. It's definitely part of the 2024-2025 training program, that topic. We have not, however, uploaded the dates because there's just a few internal things that we still wanting to close on. We're hesitant to put out the dates and only to come back to you with a cancellation or deferment and so forth. So what we will do, because we have all your details, once the dates are available, we'll just do a mail shot. My colleague from communications is here with me, is Kumbuzo Ngwenya, and I think he's taking note. So that those dates will then be communicated to everyone, but also uploaded to onto the system. But it's definitely one of the topics that we'll be delivering on this year.
And
Okay,
John,
thank you.
yeah, obviously I'm showing the website and you've got this button here that says training programs.
Correct.
So guys, if you click on that, and then you would pick up the information that John's also talking about. Okay, good. Right, let us then carry on. Of course, following on from the issue of complaints is that you might have a more serious dispute that needs to be resolved. So the aim of your dispute resolution system would, of course, be to have a mechanism via which disputes can be managed and adjudicated and ultimately disposed of, because you don't want to have a dispute that's going to be ongoing for any length of time. The idea of dispute resolution is that you have a process whereby disputes can be resolved between the parties, and you have a range of options. So as we will talk about, where you can have a low level of intervention, which is the easiest and most cost effective. And of course, the most serious would be where you're going to court and you've got lawyers and advocates and the like involved, and that obviously becomes far more costly and expensive. So you've got three options at your disposal. So number one is going to be a negotiated outcome. The parties concerned reach an amicable solution by themselves. So this could, for example, even be between two tenants that have some dispute. A mediated outcome where the parties use the services of an independent mediator, and the mediator will then help them reach a solution. Just want you to bear in mind that mediation by its nature is not something that you need to agree to the outcome. The mediator is there to try and resolve the issues between the parties and assist them at achieving a settlement. And then an arbitrated or adjudicated outcome. So that's going to be where the arbitrator actually makes a decision. So the lowest level of that would be somebody who's appointed as an arbitrator. The highest level of that would be where you'll end up going to court, and obviously the magistrate or the judge is then making the decision. So the types of things that can cause conflict generally within the social housing program, so things like issues that happen within families, things that happen between tenants and staff members, between tenants and the social housing institution, between tenants and neighbouring communities, obviously dependent on where the development is located. And then to go deeper into those types of issues, so obviously we've got the higher level reasons as to why conflict can occur. So if we look at this in a little bit more detail, you can see the types of things that would cause conflict between tenants themselves and tenants and the social housing institution. So rental amounts and increases, and obviously the things that we discussed yesterday, where I'm staying in a 2-bedroom unit and you staying in a 2-bedroom unit, but you paying half of what I'm paying. So that's not fair. The handling of security deposits, so what happens with deposits, service payments and who's responsible, for those service payments, the method of payment, maintenance and repairs, service offering, so what it is that you are providing, and you might very well have promised certain things up front and you haven't provided them. Consistency in the management approach, so how the development and tenants are managed. Remember, again, as I've mentioned, you've got a family member that's staying in the development and they showed favoritism, so that's going to potentially cause a problem. Unclear, biased and inconsistent communication, nuisance, eviction from social housing, health and safety issues emanating from the failure to respond to requests for housing repairs. So obviously that's going to be a maintenance issue, and interpersonal issues relating to dealings with other tenants, so the way in which tenants themselves interact with one another. So a lot of these issues can be managed with proper and ongoing communication. And that's why, based on what we discussed yesterday, the continuous and clear communication is very important in order to stop these types of things from happening, so that people understand that, just a simple thing like you're paying rent, but you also have to pay for utilities. That you don't have a tenant that thinks, well, I'm paying rent, it includes everything. So tenants need to understand what it is that is required of them. And that's why, and both John and I mentioned this yesterday, the pre-tenancy training is very, very important. Because your pre-tenancy training is going to lay the groundwork for you and hopefully assist in reducing the incidence of disputes that may arise and complaints that may arise. So what do you need to do as a social housing institution? So the types of things that you need to be proactively involved with. You've got to prevent conflict from getting worse. So you can't just leave the conflict to fester. You've got to attend to the conflict. You need to improve cooperation between all of the parties. You've got to build consensus, build trust, build teams, stop people from being hurt or exploited, stop resentment or bitterness from building up, address needs and concerns, encourage joint decision-making, improve and strengthen relationships, prevent the potential for violence, find creative solutions to problems. And I think, John, coming back to the question that was asked earlier, I think it was, who was it that asked the question earlier about using outsourced property management, is if you're using outsourced management, can you actually achieve all of this? So that's why you need to have that capacity in-house, is to be able to do all of this and not find yourself in a situation where things get completely out of hand, and then you obviously are now looking at more serious interventions to solve the problem. So as I've already mentioned, how do you stop these things from happening? So number one is to keep residents informed. So that's the communication issue. Number two, provide support services to reduce tension and stress in the lives of residents. So this might be, very simple interventions like access to primary health care, maybe assisting new mothers with things like breastfeeding classes, or how to actually access breastfeeding classes, through to, of course, more serious issues like people who've got substance abuse issues or addiction, and how they can actually access support in order to help them to get over that addiction. You need to plan and design properties to reduce areas of conflict, such as intrusion of privacy and noise levels. So again, your professional team becomes very important, because the professional team needs to design the development in such a way that you're going to get the maximum out of communal living. So you are living in a multi-unit dwelling community. There are lots of people who are living close to one another, but you want to make those living conditions as pleasant as possible for everybody, and have the other amenities like playgrounds for kids, communal areas, possibly braai areas, people can then meet after work or on the weekend, and you build a true sense of community. Once you provide these services, the need for complaining and the incidence of conflict should reduce very significantly. So that's why for everybody that's going through this process, where you are now starting this process of accreditation and project packaging, it's very important that you understand this, that you're a partner in this community building exercise. This is not about, accessing a grant, trying to make money, and you see it as this ongoing money-making exercise. You really are playing a very important role in providing housing to certain members of society and building those communities on an ongoing basis. You would develop codes of conduct for residents and staff. And also, as I mentioned earlier, important that staff are trained so that they know what's acceptable behavior and what isn't. And then I've already mentioned the things like counseling services. So to have successful resolution of conflict, so the dispute resolution system that you have in place, and it's not dissimilar to what we spoke about a little bit earlier, is that you would need to have a system that's accessible. So in other words, if somebody registers a complaint and that complaint is not addressed, so what's the next level that they can go to, so that there's a more senior person that they can get to. So the system is accessible, it's fair, which I've mentioned on a number of occasions. There's an understanding that there's equity in the balance of power. So we don't want to have this situation where we are the landlords and we will tell you how it works, and your job is you pay the rent and you keep quiet. So we can't have that. Again, it's a partnership, and it's about building that partnership. So the next 2 points go together with that, the building of trust between the parties. You don't want to have any mistrust between the parties, having mutual respect for one another, and that goes both ways. You also want tenants to have respect for you as the landlord and what it is that you are doing, what you are providing. A willingness to be involved in dispute resolution. So you also don't want to have tenants who are not willing to be involved in dispute resolution and just want to moan and complain. So, we want to say you have a genuine issue, there's a genuine problem that needs to be attended to. And how do we do that? Acceptance of the system and how it works, and then communication so that people understand how everything works and the way in which it operates. So the lowest level of dispute resolution, as I've mentioned, is negotiation. So here people will voluntarily agree to discuss and resolve their issues. So you would have generally a less serious dispute that has arisen, or a less serious complaint, and we can sit down and we can chat about it. What's important are the bullet points that I've indicated at the bottom of the slide. In order for a negotiation process to be successful, it's very important that these principles are followed. So number 1 is to give each other the space to be heard. So guys, in this regard, it's also quite useful for you to just go onto something like YouTube and Google things like body language and see what people do. So for example, if I'm sitting here like this, I'm not really showing my willingness to engage with you, because by folding my arms like that, I'm blocking myself from engaging with you. So as I said, I'd encourage you to go onto YouTube and just go and have a look on YouTube and just search there for body language or tutorial on body language, something along those lines. And it's very interesting when you start to recognize the signals that people give you with body language, that you can actually get non-verbal clues as to what is going on. So each person needs to give the other person the space to be heard. You've got to identify disputed issues. So what are actually the problems? So can we actually work out, what the problems are, identify the individual needs that underlie the disputed issues. So how do we resolve, this problem? And we need to be sensitive to people's issues. So you might have, let's say, a neighbor who's complaining about the neighbor next door and they've got noisy children. But the actual underlying cause of this is the fact that the neighbor who is complaining is unable to have children. So physically they're unable to have children. So for them, it's a very, very sensitive issue to be around young children because they can't have their own children. So it's really to understand these types of issues that you can deal with them in the sensitive manner that's required. So that's point number 3, identify the individual needs that underlie the disputed issues. 4, collaboratively explore options to satisfy the identified needs. So how can we resolve this problem? What can we do to fix the problem? And what are the alternatives to pursue if a negotiated solution is not found? So if you actually can't come up with a solution, so what do you then do? Okay, how are we going to handle this? What are we going to do? Now, negotiation can take place between the parties themselves, or it could be with a third party who is assisting to facilitate the negotiation process, in which case it becomes more of an issue of mediation. So we've got a third party involved, then it's more mediation. Right, so let's see what Pumzile says. Be careful with body language. It's key to understand the community or society you're dealing with. And there, yeah, so Pumzile, you're 100% correct. Okay, you are 100% correct. And, some of the examples I use in some of the classes that I do is that we know that in certain parts of African society, that younger people don't look at older people. So it's more a sign of respect that I'm not going to look at you directly in the eyes. Yet when you look at the traditional analysis of not looking at somebody in the eyes, it means that they're lying. So that's sort of the Western interpretation of not looking at the other person in their eyes. It's because you can't make eye contact because you're lying. So Pumzile, you're 100% correct. I think that's a very, very good point that you're making. Very interesting. That really is very interesting. So for the negotiation process to be successful, so both parties need to be aware of the following: focus on the problem, not the personalities. That's the idea of play the ball, not the man. Communicate well, manage your emotions. You don't want things to get out of hand. Look for a solution that will work for everybody. Avoid unfair tactics and avoid blame and manipulation of others. You really want to solve the problem. So it's not about trying to apportion blame and you did this and that happened, and in November last year the following happened and then you did that, and you'd also need to be able to move on. As I've indicated, so mediation would be a process where you're using a third party to help with the negotiation. So the mediator would then be skilled in trying to find an acceptable solution. Again, guys, depending on the type of dispute, so especially where you as a social housing institution don't want to get involved in dispute resolution, there are free services that one can access. So you've got something like what's called FAMSA, I think it's FAMSA, something like the family mediation, family, something along those lines, where you can actually access free counseling for people, especially if it's an issue within the family, and you can then have somebody who's skilled in things like social work and those types of issues, because you also don't want to get involved in the middle of a dispute if you don't have the skills to be able to resolve the issue, because it could actually make things worse. So the mediator will define and clarify people's issues, try and obviously assist them with that, reduce obstacles to facilitate more positive communication with the parties, explore possible solutions, so to help them to resolve the dispute, and then, of course, to reach a mutually satisfactory agreement between the parties. Conciliation is another word that you might come across. It's very, very similar to mediation, except with conciliation, the conciliator is more, more prescriptive in terms of saying, you should do this and you should do that. The mediator takes the role of helping the parties talk to one another and to achieve some kind of resolution, whereas the conciliator takes a more active role in finding solutions and saying to people that, this is the way that things should work. But the conciliator can't make a final decision. Neutral evaluation. So this is a process where parties to the dispute will present all their facts and evidence. They'll have a third party who's going to evaluate the dispute and the most effective way to resolve it. So neutral evaluation now is really what we call arbitration. And what's happening is that the arbitrator makes a decision. The difference between neutral evaluation and arbitration is that in neutral evaluation, you present all of the information to the third party, they make a decision, whereas with arbitration, it's a more active process. The arbitrator asks questions, might ask for additional information, might ask for parties to come and give evidence. So the arbitrator is acting almost like a judge, more so than the neutral evaluator. What would management be responsible for? Obviously, what is the dispute resolution? Liaising with entities like the Rental Housing Tribunal, and of course staff would be responsible for the communication process with complainants, ensuring that due process is followed, that it's fair to everybody, negotiating and resolving of the dispute, and then referring to the Rental Housing Tribunal if necessary. All right, any questions or comments there? Anything that you want to add? John, just flowing on from our discussion from yesterday. So Phumzile, I'll come to your question now. So John, maybe you just want to give all the delegates perhaps some insight into one major dispute that you can remember in a social housing development and how it was resolved. So perhaps if you just give that some thought, let me take Phumzile's question. Phumzile?
Thanks, Graham. Regarding this arbitration, of course, there are costs involved, and who carries those costs? For instance, if as the property management entity, we win the case, do I then, because we know that the people that you're dealing with do not have the capacity or the resources to be able to carry the cost for legal cost and all of those costs, who then does STRA actually come in and help, or how does it work?
Yeah, look, Phumzile, I think John's been quite clear is that this is not something that STRA is going to facilitate. It's not one of the services that they provide. STRA's concern would be where you've got a major issue in a development, which is almost causing, let's say, like the collapse of a development. So that's where STRA would obviously look to intervene to try and provide some assistance. Phumzile, I suppose, look, to answer your question, that normally what would happen with arbitration is that the parties would share the cost of arbitration. It's much cheaper than going to court and and briefing an attorney and getting involved in a whole legal process, but there's still a cost involved, so parties would still need to pay the cost. That's why, Phumzile, one of the options available to the parties is to utilize the Rental Housing Act and the Rental Housing Tribunal mechanisms, because there's no cost involved in that. It's a very cheap process. So you'll see, I'll talk about that when we finish section 10, and then that will give you some further insight.
Okay. Okay. Thank you.
Okay, good. Carisha?
Good morning, Graham and John. Thank you. So my question that I have is with regards to, rentals not being paid. I know, you in your previous topics that you covered, I think yesterday specifically, one of the items was that, as SHIs, I do understand that we are responsible for ensuring that we have proper systems in place, that our lease agreements are signed by both parties, that all procedures and protocols are followed, and that we have our documentation in order. But, this is a serious concern because, KZN, for example, was hit with quite heavy floods in 2022. And there was a situation that arose where people were displaced, and we had to find accommodation for temporary accommodation. But what had happened was that once displaced people were placed in these temporary accommodation, it was difficult to now get them out of there, because they felt, the Constitution says everybody has a right to housing, but there's another portion that everybody forgets about, right? And then, so in social housing, how do we address that from an SHI's point of view, whereby we have tenants, we've done the necessary background checks, everything ties up, they move in, and everything is fine until somebody instigates something with the tenants, where you have a tenant who now says, okay, it's social housing, it's a grant, we have a right to these units, we shouldn't be paying rent, and they just stop paying rent. And now you as a SHI, number one, you're losing out on rental, and your only other alternative obviously is to try and maybe evict them. But then it becomes a little bit more messier, and I've seen cases where in Johannesburg and even in Cape Town where SHIs have had to go to courts to now evict tenants, and it's a long and lengthy process. And as Phumzile noted, there's legal costs involved, and again, there's a lot of victimization for paying residents as well within the development, who are now saying that, listen, those guys are not paying rental, why must we pay rental? So it becomes like, again, we're talking about, boycotts within the development. So, and obviously, with the law is a lot for tenants more than a landlord. And one of the, for example, PI says, prevention of illegal evictions. So how then do we follow process in evicting a tenant? Because on one side, the tenant has a right to either find alternative accommodation, which we have to give them that right, or we place them in an alternate accommodation. So in the interim, whilst this is carrying on and we following the legal processes, what happens with the rental? Because the SHI is still liable for maintenance costs, management costs, municipal costs. Is there anything, if we follow the processes in terms of, the mediation and arbitration and all of that, and we've now even outsourced an external member to come in and try and assist us. And if that still fails, does SHRA offer any assistance in helping the SHI to deal with certain these kind of scenarios? And what happens there? And in terms of that period where there's, for example, a legal case taking, and the courts take a really long time to make a judgment, or in a case like this, does SHRA offer some sort of compensation for loss of rental income for this period? That's basically my question, and I think it's mostly directed to John.
Carisha, it's a very lengthy question. Let me give you a very shortish answer. So number one, what's going to happen in that case is that you're obviously going to be losing that rental income. It's as simple as all of that. Number two, you're not going to be able to turn to SHRA to help you with that loss of income. And Carisha, I think as we've mentioned, so this is, it's not a sector that is not going to have its problems. So you are going to have issues with non-payment of rental. You might have to go the eviction route in order to get rid of a tenant. That's part of the risk of doing business in social housing. So you've got to accept that that will happen. What I've been discussing with you a lot this morning is, and yesterday obviously we spoke about it as well, is that you want to provide services and have communication processes in place that will reduce the potential of any conflict occurring. But of course, there's no guarantee that you're not going to have situations where tenants don't pay you rent. So that obviously that's going to happen.
If I may, I think it's a very important question.
Yeah, John, it is very
I'll
important because of course it's a massive risk.
Yeah. So just a sec. If you speak to some of the best performing social housing institutions or social housing landlords in the sector, it is very much possible, to perform to the benchmark. Right now, just on the rent collection, the SHRA has set a 95% rent collection. And I'll tell you that, in our books, we have institutions that are performing at that level. So it is very much possible and doable, Karishna, to actually achieve that level of performance and sustainability for the organization. I think quite key to your operations is having a very solid credit control mechanisms in place. And if you go and talk to any of these institutions, Madula Moore here in Johannesburg would be a classical one, and interrogate some of the things that they've put in place just in terms of, credit control, because rental is your lifeblood and you cannot be stopped about that. It's beyond, of course, what you can do. There are a whole lot of things, of course, that you can do, and I guess, guys on the ground in the SHIs or social housing can best share that experience or those experiences better than we can do here. It would be to look at a whole lot of mechanisms. Madula Moore, some of the things that they share broadly in the sector is your payment modalities that you have in place needs to not only be one-sided. In other words, people can only pay rent through a bank account. So having a system that allows a whole range of payment modalities, as an example, it does make that contribution in terms of your rent collection at the end. To the point that they would tell you that they have and they deploy at some point, as part of the credit control measures that they've put in place, speed points on at the project. Goes back to, again, the point that we've re-emphasized here, the presence of the landlord or yourself as a landlord in the thing at the project level, because quite early in the month you are able to pick up who are the rent defaulters, and you are able to go in and issue and do what you need to do before even things escalate to months of non-payment of rent. There's a lot that I think as social housing landlord you can do, and it has been done and has proved to work in the sector. I'm not even wanting to go into the private rental sector. So there's a lot that can be done there. Garnishing order where you have some of defaulters can be some of the measures that you put. The point that I wanted to make is that you can't give in to this fight. It is almost a fight, because as a John tenant, sometimes the competition for resources is quite tight. It's either I have to pay Edgar's this month or pay my rent, and it has to be that made clear in the mind of a tenant that rent is but one of your primary priorities. And as a social housing landlord, that is your responsibility before, you could escalate things to the likes of the SHRA. And then again, I think someone asked a question in terms of the arbitration and the cost thereof and how expensive it is. And you're right. This is why government set up the rental housing tribunals. And these are institutions that are set up specifically to adjudicate over tenant landlord issues. Included in those would be issues of rent collection, maintenance or lack thereof, and many other issues as well. And they are extensively used as one of the mechanisms in the sector and by the social housing landlord. So have a combination of things in place to basically allow and enable you to perform what you are set up to perform. We go to the point that your core function as a landlord is that of tenant management and property management. So building those systems, building that in-house capacity to be able to perform what you're set up to do. I think rental tribunal, if I was to say, it almost sounds to me like your CCMA of social housing. Not of social, of the rental housing market broadly. So there, for what I know, Graham will also go into that section at some point, if it's not done so as said. It's a process that has been made. A platform that is affordable and accessible, not only for the landlord, but for the tenant as well. And I would even beg to differ in terms of one saying the laws of this country and therefore the Rental Housing Act is more in favor of tenants than the landlords. Because if you speak to many of the institutions that have had to take on cases, they speak of the success of the rental. So these instruments are quite effective. I think it's in you knowing these institutions and building the relationships that you need to build with this institution to be able to resolve and address some of these problems in terms that feature in your operations.
And John, can I also just add as well, because obviously Carisha's highlighting some of the major things that can obviously happen. And I want to just say to everybody is that where you have a situation where you have arrears, address it immediately. Don't let it go for 2 or 3 months. So you need to have a very strict policy in place. Rent is payable by the 1st of the month. If rent hasn't been paid, by the 3rd of the month, the property manager or the supervisor on site provides a letter to the tenant indicating that they're in arrears. Rent needs to be paid then by the 5th. If it's not paid by the 5th, then you need to then start a process so that tenants also know that they're not going to have 2-3 months before you even start communicating with them. So it's very important that you address arrears as soon as it happens. Because, Carisha, obviously, as you are correctly pointing out, you start to have these problems and it snowballs with other tenants in your development. And, within 6 months, it's going to collapse the whole development. Because the rental is obviously the lifeblood of what keeps this thing going. All right. Anything else? John, do you want to give everybody a short break?
Sure, I think we can do a 5 minutes.
Yeah, that's fine.
Stretch.
I've got section 9 and 10 to do, which are very short sections. It won't take long for me to go through them. And then I'm going to focus on the Rental Housing Act.
Yeah. So let's take a 5-minute body break. It's 2 minutes before 10 to, so we can come back. What is it? 5 to 11.
5 to, perfect.
Yeah. Yeah.
Can you hear me?
Yes, loud and clear,
Yeah.
Graham. I
Yes.
hope
Alright.
everyone can.
Yeah. Sorry, I think we just had a bit of an internet problem there for a moment.
Sure.
Okay, so guys, that's where we had got up to, was the discussion of dispute and conflict resolution. So the last two topics that I'm going to talk about here deals with tenant satisfaction survey and the exit of the tenant at some point. They are shortish chapters in your manual. As you'll see, they're only a few pages each. So you need to do tenant satisfaction surveys on a fairly regular basis. The surveys, really what you want to get out of these surveys is for tenants to tell you what improvements can be made to the property, anything that's maybe lacking, suggestions that can be made, what needs to be done insofar as maintenance is concerned, to help the social housing institution also identify trends within their tenant population. So if things are maybe changing from a demographic perspective, you also want to get feedback on customer service and the quality of the service that you're providing to your tenants, and to provide the social housing institution with data, because this would become very, very useful when one looks at the next development, and the feedback that you're getting from tenants will then help you with that next development. So your tenant satisfaction survey will be conducted every 3 years after a project is delivered and let. Of course, you could do it on a more frequent basis. You don't have to do it on a 3-yearly cycle. You might want to do satisfaction surveys on a 6-monthly or annual basis to get that continuous feedback. And guys, it's important that you get a decent sample size. So it's suggested that a sample size of between 40 and 50% of the residents in the development will be suitable. If you're only getting 5 or 10% response, it's not representative of everybody who is in that particular development. And it's suggested outsource this to a specialist research company. That's also very important in terms of, of ensuring that you get the right feedback from residents, as opposed to sending your property manager around, or your supervisor or caretaker around with a clipboard and forms to fill out, and they're not getting honest, they're not getting honest feedback as a result. So you can also, of course, use things like SurveyMonkey, which is, it's free. It's something that's also anonymous, so that people feel comfortable in responding.
Hi, Graham.
Yes.
Sorry, I see that your screen is frozen. In fact, even the presentation
John?
was still on. Can you hear me?
Yes.
Yeah, no, I was just saying the screen is frozen. In fact, the presentation has not moved from, I think you were showing that section on arbitration. And well, from what you are saying, it looks like you've moved to a different slide altogether.
Yes.
Can you just play around with that and see if you can?
Okay. What are you seeing now, John?
Okay, it's on section 8, conflict and dispute resolution. Well, it still says arbitration.
Sorry, I know, as I said, we were just having it look like a bit of an internet problem there. Let me just escape from that. Let's try that again, just so that I can show everybody what it is that I was talking to. What do you see now, John?
I hope all is everyone okay? Because I see Karishna says it's probably on my side. Yeah.
Morning, everyone. Yes. Sorry, John. Yeah, it looks like it's just on your side.
It's
Because
on my
even when
side.
Graham was on and off, I think it's just on your side. You can see what's going to us.
Okay. All right. No, thanks for that. Then, guys. Go ahead, Graham.
Okay, so everybody else okay?
Yes, it seems.
Yep.
Okay. Very good. Thank you, guys. All right. Any questions around the tenant satisfaction survey? I think it's pretty straightforward. So I don't think there's really much to talk about there, but obviously an important part of the feedback that you're getting. And then what do we do when the tenant exits? So you, at some point, are going to get movement of tenants. So tenants are going to move out either voluntarily or not voluntarily. You need to, of course, have a policy and procedures in place when this happens. Things like the notice period. Let's just maybe just highlight this here. So I just want to highlight these points here. So the notice period, execution of maintenance. Somebody's moved out, you might need to repaint. There might be things that need to be fixed in the unit. Closing of the account with the tenant. Tenant's going to want their deposit back. So there might be damages that need to be fixed. So you, of course, need to take that out of the deposit. Any interest that may be accrued on the account as a result of non-payment, municipal charges that might be outstanding, and legal fees if applicable. So really the 6 things that you would need to be aware of would be the giving and accepting of notice to terminate a lease. So this would be from the tenant side. So normally that would be a calendar month's notice. So you would usually accept notice on the 1st of the month, and then the person would then provide that 1 month's notice that they're going to be vacating the unit. Just in this regard, so something to make you aware of, we would obviously look at what the lease says in terms of the end of the lease, so at what point in time the lease is going to be terminating. But I also want to make you aware of the provisions of the Consumer Protection Act, and the fact that in terms of the Consumer Protection Act, so it's Section 14 of the Consumer Protection Act. So I'm going to type it into the chat box for you. So Section 14. Okay, so Section 14 of the Consumer Protection Act. The tenant can give 20 business days notice to terminate the lease. So in terms of the Consumer Protection Act, you can terminate a fixed term contract by giving 20 business days notice. So please bear that in mind. The Consumer Protection Act also allows for penalties to be levied where a fixed term contract is terminated before the end of that particular contract. And guys, just for you to be aware that generally in the property industry, what's become the accepted norm is that the penalty would be 2 months rental. So if a tenant wants to vacate early, you would, and that tenant then, let's say it's a year's lease, and 6 months into the lease, they now want to vacate the premises and they want to cancel the lease agreement. They can do so in terms of the Consumer Protection Act. You cannot hold the tenant to the full duration of the lease, but you can levy a penalty for early termination. Just also bear in mind the levying of that penalty would in essence be in lieu of damages that you would be suffering because of early termination of the lease. So guys, quite simply, what that means is that if the tenant terminates the lease and you've got a new tenant that can move in at the beginning of the next month, you haven't suffered any damages. So it wouldn't then be fair to charge the tenant that's vacating for that 2-month period of damages, because you're not going to actually suffer any damages because you've got a new tenant that is that's free to move in at the start of the next month. So as I say, just please be aware of that. Very important that when you get to the point of your lease agreement, make sure that you consult with an attorney that is well versed in these issues so that the lease agreement can then be fully compliant with the law. You don't want to have a lease agreement that, you know, one of your staff have sat down and drawn up the lease agreement and found things on the internet and pulled things from here and pulled things from there. You do want to have a lease agreement that's fair to the parties, but also complies with the legalities of what's required in terms of either the common law or legislation. Giving and accepting notice to terminate the lease from the social housing institutions perspective. Just to please bear in mind that the social housing institution does not have the same right to terminate the lease on a month's notice in terms of the Consumer Protection Act like tenants do. But there may very well be reasons as to why that lease would be terminated. So, for example, the lease has come to an end and you may very well have had some difficulties with that tenant, so you want to give them a month's notice to vacate because you don't want them to stay on. You might also find that the tenant is in a situation where, for various reasons, they do need to move. Let's say, for example, they've been relocated to a different province. The lease has come to an end and, you know, they've spoken to you about they are vacating, they're not vacating. And so you've got uncertainty as to what's going to happen. Once the lease has come to an end, you could then give them a month's notice in terms of the lease agreement, and you could then terminate the lease. And then, of course, coming back to the point that Carisha was making earlier and the question that she asked, where you have a tenant that is not paying, that tenant will be in breach of the lease agreement, and you would then give notice in terms of the breach of that lease agreement. Just on this particular point, just want to make you aware that you generally cannot terminate a lease the first time that a breach has happened. So the principles of our law work along the lines of equity and fairness. If a tenant is in arrears with the rental, you would notify them that they are in arrears. I spoke about that a little bit earlier before our break. So you would notify them about that. You know, what you would do is you would give them an opportunity to rectify. What you can do, and you can also have this in your lease agreement as well, is you can then write a letter to the tenant and you can then say that in the event that the tenant is in breach of the lease again in future, that they will not be informed that they're in breach of the lease. Their lease will be summarily cancelled. So in terms of the law, you are entitled to do that. Obviously, from a business operations perspective, you may not want to. So you may want to give the tenant an opportunity to fix the problem, but you also don't want to have a tenant that's habitually late with the rent and it's causing you problems, and you're always following up with that tenant in order to make sure that the rental is paid. Right, then point number C is communication. So whether the tenant is giving you notice or you giving the tenant notice, it needs to be communicated to each particular party. So this would, of course, also be part of your pre-tenancy training and your ongoing training. When you receive notice, you would want to then give some type of acceptance of the notice. So you would want to then communicate with the tenant that their notice has been received and has been accepted. The tenant might also want some kind of a letter of good standing. So when they go to the next place and they're going to rent from someone else, they might want a letter from you indicating that they have been a good tenant, they have paid their rent, and they are in good standing. What you will want to do is undertake any maintenance. That's point D. So anything that needs to be fixed in the unit, so you'll want to undertake it. What you'll also want to do is an exit interview. So you'd really want to sit down with the tenant and ask the tenant why they're leaving. Were there any problems? Is there anything that, perhaps as a landlord you could have done better? And that's, of course, to pick up information for you to improve your service as a landlord. And then point F, so you would need to, of course, close off all of the financial issues. You would want to return the deposit to the tenant. And then, obviously, if there are any damages that need to be fixed, if that money needs.
We seem to have lost Graham. Is it just on my side?
Yeah, we've lost
I can't hear him as well.
Yeah.
I think for
We lost
everyone, John, I think we've all
Okay.
lost him.
All right. Let's try and see,
Yeah.
get him back in.
Sorry, guys, can you hear me?
Hi, Graham. Yeah, we lost you for a minute there.
Yeah, it looked like also again there was a screen freeze. Did you hear up to the point that I was making about the exit interview?
Yeah.
And the closing off of the accounts. Okay. All right, good. So I think just the internet's been a little bit patchy. So management would be responsible for developing and reviewing the tenant exit system, communicating the relevant, that should be Rental Housing Act clauses to the client service staff, ensuring that you have the capacity and the resources to finalize the exit of the tenant. And then obviously you want to make sure that you've got statistics with regards to the movement of the tenant. Remember also that you don't want to have too much movement in your development. It's not good either, because the in and out of the development, it's wear and tear. You've got people moving out and then they're banging the wall with their furniture, and then you've got to fix it, and then you've got to repaint. So you also really want to try and keep that movement to a minimum where possible. So any questions anyone wants to ask about the tenant satisfaction survey, the exit interview? All good. I think it's fairly straightforward. All happy? Okay. John, I don't think we've got any questions in the chat box. No, what does Carisha say? Early termination should be included in the lease agreement, so the tenant is aware of it up front. Yeah, fair enough. Agreed. And then as far as the exit is concerned, so staff would be responsible for receiving notice to vacate, issuing the termination of lease letter, issuing the acceptance of notice letter, and then, of course, making sure that the tenant is aware of all issues around the vacation of the unit. So handing over keys, the exit interviews, communicating around the deposit, what the tenant would be entitled to, ensuring that the tenant vacates the unit, and then, of course, closing off with whatever final correspondence needs to be done. All right, so guys, before we actually go on to talk about the Rental Housing Act, I just want to draw your attention to the manual itself, which I'm going to show you right now. So you should see the manual on your screen now. So section 11 is all of the annexures that I've provided you with. So you'll see that Annexure A is the Government Gazette dealing with the income bands. So that's just a page long. And then what I've done is with Annexure B. So guys, can you see Annexure B? Is it projecting on the screen?
Yes.
You can all see it. So you can see that it says summary of steps in the tenant management process. So everything that we've spoken about yesterday and today is summarized here for you. And I've given you all of the different tables in order. So what I would suggest that you do is you actually print out Annexure B, and you use that as almost like your quick reference guide to all the steps in the process. So it's a summary from section 1 all the way through to section 10. And as I say, I think that you'll find that quite useful as a step-by-step process. Let me just go back to the manual. So there you can see it. And you can see, so each step of the process, there's a table that gives you the detail of that particular process. So it is quite a few pages. But again, you might find it very useful to print it out. And so there you can see what we've just spoken about. So there's dispute resolution, tenant satisfaction, tenant exit. Then the budget template that I mentioned to you yesterday is Annexure C. So again, you can print that out and you can use that for your tenants to complete. Then Annexure D is about the Rental Housing Act, which I'm going to discuss with you now. And then I also want to draw your attention. You'll see I'm going to talk to you about the rental collection process as well, which is Annexure E. And then your last few annexures at the back. Some interesting articles that I've put in for you there about what to do when a tenant falls into arrears. So I think, Carisha, you'll enjoy reading that. I think it will be very useful for you. So please refer to obviously all of those annexures when you get the manual. John, so Naledi's asked, is the manual accessible on the SHRA website? Are you going to put it up on the SHRA website, or are you going to email it out to everybody?
No, it will only be sent to participants on in this program.
Okay, only to participants. All right.
Yeah.
Good. Right, so guys, let's then turn our attention to the Rental Housing Act, a very, very important piece of legislation. I just want to give you some of the background to the Rental Housing Act. After the Second World War, we had a piece of legislation that was enacted, which was called the Rent Control Act. So this was round about 1948, if I remember correctly. I don't know, somewhere around about there. You had people who came back from the war. Economically, things were very difficult. So you generally get, after a major conflict, you get a depression, because the whole economy has been geared around military production, and obviously businesses have closed down and people have lost their jobs. So what the government did similar to a lot of other governments around the world, is they passed a piece of legislation called the Rent Control Act. The idea being that in certain areas, in the South African situation, it was the inner cities. So it was in Johannesburg, in Durban and Cape Town. Rent control areas were created. And the impact of that was that rents could only be charged according to a particular formula. It was obviously very, very problematic for a lot of landlords because they weren't generating the rentals that they required in order to make their developments economically viable. Over time, so already by about the 1970s, the impact of the Rent Control Act had lessened. In terms of the Rent Control Act, something called the Rent Control Board was created, and the Rent Control Board demarcated certain areas to fall under rent control. And as I say, already by about the 1970s, a lot of areas that fell under rent control had been scrapped and repealed. So through to about the 1990s, rent control almost became a non-issue. We never had a piece of legislation that regulated the relationship between landlords and tenants. So the only piece of legislation that we had dealing with rentals was this Rent Control Act, which had been passed in the 1940s, and obviously it was very, very outdated. When the government changed in 1994, there was a whole lot of new legislation that was enacted. Of course, what we had was the repeal of all the apartheid-based legislation. So all of that legislation was taken off of the statute books. Obviously, things like the Group Areas Act and those types of pieces of legislation. And one of the areas of concern that government had was to have legislation in place that would regulate the relationship between landlords and tenants. And so in 1999, the Rental Housing Act was implemented. At the time, it was reported that the Rental Housing Act was a new Rent Control Act. It was going to really make rental property unviable. Landlords beware, okay, the government's coming to get you. So you know how media report all of these things. And I think, as John mentioned earlier, the Rental Housing Act is actually a very balanced piece of legislation. So it's important that you're aware that the Rental Housing Act provides protection to both landlords and tenants. So that's what it's designed to do. It is not a piece of legislation that is there to only protect tenants. So, and again, also when you have a look at, if you just go online and you Google things about the Rental Housing Act, you know, you'll also still find it being reported that it's a piece of legislation that protects tenants and it provides no protection for landlords. It's not true. Okay, it is a very, very balanced piece of legislation. So I just want to say that up front to you, just so that you are aware that it is in fact a balanced piece of legislation. So the main purpose of the Act, you can see there's 4 or 5 things: to define the responsibility of government relating to rental housing, to promote mechanisms, to create mechanisms that will promote the provision of rental housing, to promote access to adequate housing through mechanisms that the state will obviously enact. And then you can see that we talk about the creation of the Rental Housing Tribunal and the issue of conflict between landlords and tenants. So again, as I say, that's really the purpose of it, is to ensure that we have some balance with the protection provided to landlords and tenants. Sorry, guys, if you just give me 1 moment, I just want to close the door. Thank you. I've just got a bit of a wind that's blowing through the door. So the main highlights of the Act that are important for you. So firstly, Section 4, capital A, you can see subsection 2, tenant may request the landlord during the period of the lease to provide him or her with written proof in respect of interest accrued on the deposit. So a tenant can ask you as the landlord, what's happened to our deposit, and can we have written proof that the deposit has in fact been deposited into an interest-bearing account. So that, guys, is something for you to be aware of, is that deposits that you take from tenants need to go into an interest-bearing account. You don't have to invest the money in an interest-bearing account at the best interest rate available. So you can open a trust account at any bank. Trust accounts normally attract very low rates of interest, and you can then put the money into that particular trust account. So it doesn't have to be at the top interest rate that you can find anywhere, as long as it's invested in an interest-bearing account. Subject to Section 4B3. Now, Section 4B3 talks about the fact that a tenant would be responsible to pay for things like damages. So a tenant is then entitled to receive their deposit back, plus any interest that's accrued on the deposit, obviously less any money that they still owe. So there might be utilities that are outstanding. There may be damages that need to be paid for. So that's what Section 4B3 talks about. All right, ladies and gents, what's very important to understand is that the tenant must, on request by the landlord, make himself or herself available to conduct a joint inspection of the dwelling at a time convenient to the landlord and tenant. So this is important both when moving in and when moving out. So you need to do a joint inspection when the tenant moves in, and you do a joint inspection when the tenant vacates. So when the tenant moves out. You'll see I'll talk to you about what happens if the joint inspection doesn't occur. And so I'll come back to that a little bit later. Importantly, subsection 5, a tenant has the right during the lease period to privacy. So you as the landlord have the right to inspect. You'll remember that yesterday we spoke about house visitations. It was one of the topics that we discussed, but you can't just turn up whenever you feel like it. So you can't just decide, right, tomorrow morning we're going to do inspections. The tenant, in terms of the Rental Housing Act, has the right to privacy. And what you would do is you would need to make sure that you inform the tenant timeously of when you want to do the inspection and give the tenant sufficient notice. Subsection 6, the tenant's rights against the landlord include the right to not have his or her person or dwelling searched. So as a landlord, you can't do that. So you can't just say, right, we're searching you. If you've got reasonable suspicion of, let's say, some criminal activity, that the tenant is involved in things like the distribution of illegal drugs, then it is far better that you get the police involved. It's much, much better to keep your staff out of any of these potential issues, which can land up being very problematic for you. So the tenant has the right not to have his or her possessions seized, except in terms of law of general application, and having first obtained a ruling by a tribunal. So what are we talking about there? That would obviously be in the instance where the tenant is in arrears with the rental. And what you then do is you get an order from the tribunal or an order from court that you can then seize those movables as security for arrear rental. If a tenant is in arrears with their rent, You can't just go and the tenant goes to work and then you go and open the door and you take the tenant's lounge suite and TV and you hold it as security for rental. So you are not allowed to do that. You would need to have an order from the tribunal, or you would need to have an order of court in order to be able to do that. And the tenant has the right not to have his or her communications infringed. Importantly, in subsection 7, one needs to be aware that these rights that the tenant has also apply to the members of the tenant's household and to visitors of the tenant. So you also can't search visitors that are coming to see the tenant or seize any of their possessions. So you wouldn't be allowed to do that. Subsection 8, a tenant is liable for rental and other costs agreed upon in the lease. You can see it's very clear in the legislation. So the tenant is liable for those costs. And, you know, obviously it's important to highlight those costs in the lease agreement. You can't just come with miscellaneous charges. So you have to obviously indicate in the lease agreement what the tenant is responsible for. Also, just want to make you aware that the Rental Housing Act has, as part of the Rental Housing Act, what are called unfair practice regulations. Now, depending on which province you are in, the unfair practice regulations may differ. So I know, for example, that Carisha's in KZN. Every province has its own rental housing tribunal, or every province is supposed to have its own rental housing tribunal. Not every province does, but every province should have its own rental housing tribunal. So there are 9 provinces, there are 9 rental housing tribunals. The unfair practice regulations are not necessarily the same in each province. So those of you that are in Gauteng, if you go online and you Google it, you'll find the unfair practice regulations for the Gauteng Rental Housing Tribunal. Carisha's in KZN. So Carisha, you would go online and you could search for the KZN unfair practice regulations of the KwaZulu-Natal Rental Housing Tribunal. I think Ricardo was in the Cape, so Ricardo could do the same thing in the Cape. The principles of the unfair practice regulations are very much the same. So as an example, the unfair practice regulations are very clear that a tenant cannot not pay rent. It's an unfair practice. So even if the tenant has a dispute, the tenant has to continue to pay rent. So Carisha, that comes back to your question that you asked earlier this morning. What happens where the tenant doesn't pay rent? So quite simply, if the tenant is not paying rent, you as the landlord are entitled to approach the Rental Housing Tribunal. Let me just explain to you what the basic process is with the Rental Housing Tribunal. You would go to the Rental Housing Tribunal and you would need to obviously identify where the Rental Housing Tribunal is located. In most instances, you will find that the Rental Housing Tribunal is located in the same premises as your Provincial Department of Human Settlements. So they'll be in the same building, in the same place as the Provincial Department of Human Settlements. You would go to the Rental Housing Tribunal. You would then lay a complaint with the Rental Housing Tribunal. They open a file. They give you a file number. The Rental Housing Tribunal, then whoever you're dealing with there, so the administrative person that you're dealing with, will get you to fill in some documentation. You need to provide documentary proof. And then what will happen is that they appoint a case manager. The case manager will then investigate. The case manager will then try and resolve the dispute if it's possible. So the case manager almost acts like a mediator to try and resolve the dispute. At this point, it's not costing anybody anything. So that's why the Rental Housing Tribunal is there. In the event that the case manager cannot resolve the dispute, then the matter goes forward to adjudication by the Rental Housing Tribunal. So, Carisha, this comes back to part of the question that you asked earlier about where the tenant is not paying rent. Go to the Rental Housing Tribunal. It's in the Act that the tenant has to pay rent. It will be in the unfair practice regulations that not paying rent is an unfair practice. As a tenant, you cannot stop paying rent. And what I would suggest that you do in your pre-tenancy training is that you use this information as well to make tenants aware, and that it's very clear to them that they cannot not pay rent. It is an obligation in terms of the Rental Housing Act that they have to continue paying rent. Of course, if there's a dispute, the dispute needs to be resolved, but the tenant can't not pay rent as a form of protest. Importantly as well, as part of your protection as a landlord, a tenant may not sublet a dwelling without the consent of the landlord. So you can't be in a position where you arrive at the premises and suddenly the tenant's brother is now in occupation of the premises. It's also one of the reasons why you want to have active on-site tenant management. You want your own staff on site. Again, coming back to the issue of outsource management, so it's a reason why you don't want to use outsource management. Rights and obligations of the landlord, so these would be fairly straightforward. This is section 4B. So section 4B subsection 1, the landlord may require a tenant to pay a deposit. So you can see the first bullet point, the deposit may not exceed an amount that's equivalent to an amount specified in the lease. So you can't say in the lease that the deposit is 1 month's rent and then you tell the tenant, sorry, you've got to pay 3 months rent. It's got to be in the lease agreement. Section 4B1 as well, the second bullet point, the deposit must be invested in an interest-bearing account, provided that the rate applicable to such account may not be less than the rate applicable to a savings account with that financial institution. And as I've indicated, if you open a trust account, then it's normally at the lowest savings rate that that particular institution provides. It must be repaid to the tenant with interest, and it does not form part of the assets of the insolvent estate or deceased estate of the landlord. So even if the landlord were to go insolvent, so let's say, for example, that the social housing institution goes into administration or the social housing institution has to be shut down, the tenant's deposit will be protected. Subsection 2 of section 4B, upon request from the tenant during the period of the lease, the landlord must provide him or her with written proof in respect of interest accrued on the deposit, which I've mentioned already, provided that where the landlord is a registered estate agent, then the deposit is dealt with in terms of the provisions of the Estate Agency Affairs Act. Guys, the Estate Agency Affairs Act, in fact, no longer exists. It's been replaced with a piece of legislation called the Property Practitioners Regulatory Act. Really, all this particular section is saying is that if the landlord happens to be an estate agent, which is not going to be the case in your particular circumstance, then the provisions of the Property Practitioners Regulatory Act would apply, and that deals with things like a trust account. It's not dissimilar to what I've already explained to you, that you would have a trust account and money would then be invested in the trust account. What happens when the lease expires? So point number 1, you need to refund the deposit together with any accrued interest. And guys, please note that that is within 7 days of expiration of the lease. So you've got to do that pretty quickly. The money needs to be given back to the tenant. Point 2, you may apply the deposit and interest towards any amounts that the tenant is liable for, including the cost of repairs. So if there are any damages, the cost of lost keys. So you would then fix whatever needs to be fixed, and you then have 14 days to return the balance of the deposit. So if there's nothing that is damaged, then you've got to give the deposit back within 7 days. If there are things that need to be fixed, then you've got to give the deposit back within 14 days. And then the tenant can request, what it says, must make available to the tenant any relevant receipts. So if you've had the unit repainted, or you've had the wall fixed, or you've had to have tiles replaced, then you need to give the tenant copies of those receipts so that the tenant can see what the money has been spent on. Also, as I mentioned to you previously, the tenant and the landlord have to jointly inspect the premises prior to moving in. Remember, we did talk about yesterday the fact that any list of defects must be attached as an addendum to the lease. And you can see the last bullet point at the bottom of the page is that if the landlord fails to inspect the dwelling in the presence of the tenant, then it's taken that the dwelling is in a good and proper state of repair, and the landlord will have no claim against the tenant. So it's very, very important that you inspect the premises, because if you're not available to inspect the premises, then it's considered that there are no damages and that everything is then in order. Also, if the tenant fails to respond to the landlord's request for inspection, then the landlord must, within 7 days of expiration of the lease, inspect the dwelling to see if there are any damages. The landlord obviously has to refund any money that's owing to the tenant, but if the tenant hasn't been available for inspection of the premises when they exit the premises, then it's their problem. So, you know, it works both ways. If the landlord's not available when the tenant enters the premises, then the tenant is protected that the landlord couldn't make themselves available, so then it's considered that the premises are in a good state of repair. If the tenant's not available on exit, then likewise it's going to apply that whatever's wrong, then the tenant has to accept that the landlord has told them that whatever is wrong. So you really want to make sure that both the landlord and the tenant are available. And of course, you've got a property manager or a caretaker on site, then you shouldn't have any issues. So you, on entry, there's a joint inspection. You're going to give the tenant some time living in the premises, because obviously the tenant's not living there. They're not turning on the taps and seeing that the stove works or the stove doesn't work. So you need to also give them an opportunity to report any issues that might exist in the property. And then on inspection, then you would need the landlord and the tenant to inspect on the way out. And of course, that protects both parties. If the tenant vacates the dwelling before expiry of the lease without notice to the landlord, the lease is deemed to have expired on the date that the landlord has established that the tenant has vacated the dwelling. And then the landlord's rights arise from the tenant's breach of lease. In other words, at this point, the landlord can now cancel the lease and say, right, that's the end of the lease. The tenant can't come back and say, well, I now want to come back to the premise. So basically, if the tenant absconds, then the landlord is in a position where they can now actually cancel the lease, and that's the end of the lease. The landlord may inspect the dwelling during the course of the lease, but in doing so has to respect the tenant's right to privacy. So we've mentioned that already, that you would need to give reasonable notice to inspect the premises. And again, coming back to the rights that the landlord has, so you can see, so this is section 4B, subsection 9. The landlord has the right to prompt and regular payment of rental and any other charges, recover unpaid rental that is due and payable, terminate the lease in respect of a dwelling or rental housing property.
Hello.
So, I want you to be aware that this piece of legislation is balanced. the tenant cannot pay rental cannot not pay rental because they're protesting. The landlord is entitled to receive rent. The landlord is entitled to prompt payment of the rental. The landlord is entitled to prompt payment of any charges like electricity or water. And again, as I've mentioned, so this is very important that you provide this upfront in the pre-tenancy training, that the tenant is aware that, yes, we are equal partners in this. We are going to treat you with the level of respect that you deserve, but as the landlord, you need to treat us with the level of respect that we deserve. We cannot be in a situation where you decide, well, you're not paying the rent because you're not happy with something, or you're not paying the utility charges because you're not happy with something. So the landlord has the protection that the landlord requires in terms of the Rental Housing Act. Where was I? There, that's where we were. So that was subsection 9, the landlord's rights to prompt and regular payment of rental or any charges, recover unpaid rental. Remember, you need to get a ruling from the Rental Housing Tribunal, so you can't just go and take the tenant's lounge suite as security for the money that's owing. And as I say, you know, the Act provides you with protection as the landlord. Yes, I think that this point is also quite interesting. On termination of the lease, have the tenant vacate the dwelling or rental housing property upon expiration of the lease. So the lease expires. Your right as a tenant is to obviously have the tenant. Your right as the landlord rather is to have the tenant vacate, to receive the dwelling or rental housing property in a good state of repair, except for fair wear and tear, evict the tenant from such dwelling or rental housing property after having obtained a court order in accordance with the Prevention of Illegal Eviction from an Unlawful Occupation of Land Act. So you would have heard Carisha earlier talking about the PI Act, which I'll mention to you now shortly how the PI Act works. But I want you to see that it's very clear in the legislation that you can evict the tenant. So the tenant is not protected at all costs. So you can evict the tenant. Now let's talk a little bit about the PI Act. So the Prevention of Illegal Eviction Act is there to stop the landlord from arbitrarily evicting the tenant. Guys, what you need to be aware of, and this I think is the point that Carisha was making earlier, is that the PI Act, and this is section 4 of the PI Act. The PI Act says that if a tenant is in unlawful occupation, so obviously something like not paying rent would be unlawful occupation. So if the tenant is in unlawful occupation, then you may approach the court for an eviction order. The one thing that I do need to make you aware of, which is obviously not good, is that to get an eviction order in terms of the PI Act, you need to approach the High Court, which of course is a costly procedure to do. The PI Act also talks about, before the court will issue an eviction order, they will consider the rights of the elderly, child-headed households. There's a whole list of people who would be protected in terms of the PI Act. The one problem with the PI Act, and I can see that Carisha is going to be obviously very sad when she hears this. The one problem with the PI Act is that if the tenant has been in occupation for more than 6 months, What the High Court may require the landlord to do is to find the tenant alternative accommodation rather, before issuing the eviction order. Now, this does not mean to say that the landlord has to physically assist the tenant to move, pay for anything on behalf of the tenant. The landlord's responsibility is to identify alternative occupation. In terms of the PI Act, it is a problem in the PI Act. So I will say that it is a problem in the PI Act, because obviously it is a way in which a tenant can obstruct the eviction proceedings. And that's why I made the point to you earlier that if a tenant falls into arrears with their rental, you have to address it immediately. Do not wait for 2, 3, 4 months to go by before you address it. Tenants need to be aware that you are serious about managing the situation when the tenant falls into arrears with the rental. So on the third day, there's a letter that goes to the tenant. Day 5, the tenant hasn't paid. You would issue a second letter that they have until the 7th to pay. If they have not complied with their obligations, you're off to the Rental Housing Tribunal and you've gone to then lay a complaint with the Rental Housing Tribunal. That's also why, as a landlord, you want to have a good relationship with the Rental Housing Tribunal. Obviously, they're not going to show any favoritism. So clearly that's not going to be the case. But what you are going to want to do is to make sure that you take action as soon as possible. You don't want to have monies outstanding for any length of time, because it's going to create a huge amount of difficulty. And of course, if it does come to it and you need to then approach an attorney and you need to start eviction proceedings, then it's important that you find a firm of attorneys that are well versed in this. So remember that what you're going to want to do is that first letter and giving the tenant a couple of days to rectify the breach, then the second letter, and then from there straight to the Rental Housing Tribunal. And if you are not making any progress with the Rental Housing Tribunal, then you would need to resort to legal action, but you have to attend to it immediately. Don't wait for something to happen on its own, because it's not going to happen on its own. You are going to need to manage the process, and unfortunately it is costly, that process, and it is time consuming. And again, coming back to the question that Carisha asked earlier, unfortunately the legislation is not set up such that you could go to SHRA and say to SHRA, look, we're out of pocket for 6 months rental, can you please assist us? So there's no grant that you can pull down on in order to help you with the arrears that you're sitting with. Right, so unfortunately I can't give you better news than that, other than to advise you to make sure that you are addressing the issue as soon as it happens. As the landlord, you need to obviously provide the tenant with a dwelling that's in a habitable condition. You need to maintain the dwelling, and you need to provide basic services. So those basic services would be things like water and electricity. One thing that I do want to address with you is whether or not the landlord can cut off water and electricity. So are you able to do this? The answer to that is no. So as the landlord, you cannot terminate the utilities. I see Tammy's actually just asked the question, what if they're paying rent but not the utilities? So the only way in which you can cut off the utilities is if the supplier of the utility has terminated the supply. So you would need the city council to terminate the supply. Of course, in a multi-unit development, that's very difficult, because how do you get the city of Johannesburg to terminate the supply of electricity to Unit 12? Obviously, it's not, it's not possible to do. So the principle is that as the landlord, so you cannot terminate that supply. So guys, what are your solutions here as far as electricity is concerned? So how do you stop yourself from being in the position where you've got these huge unpaid electricity accounts? So what do you do when you develop the unit?
Graham, sorry, would prepaid be a viable
Correct.
option?
So that's your solution, is you put in prepaid meters. So you install prepaid. You can also get prepaid water meters as well. So you need to investigate this technology to take yourself out of the utility issue, so that you stop yourself from being out of pocket with the utilities. To come back to Tammy's question, what if they are, they're paying the rent but not the utilities? So this would be in the event of postpaid. So you being billed in bulk, and then you are you billing each tenant individually. Well, Tammy, if you're in that particular situation, then you would still approach the Rental Housing Tribunal for the recovery of the arrears on the utilities. But the way to stop yourself from being in this position, so very simply, is put prepaid in. The tenant doesn't want to pay, well, then they don't get supply to their unit. And then you as the landlord are not out of pocket for that money. So the rental collection process, so just to highlight these steps to you. So steps to collect the deposit from the tenant. You can see step 1 is that you would prepare the invoice for the deposit. Once the tenant has been approved, then you would then obviously create the rental deposit invoice, and then you would give that to the tenant. The tenant would then need to pay the deposit that is required. You need to issue a receipt. This is step 2. You would need to issue a receipt for the deposit, and you would of course then need to record the fact that the deposit has been paid. Remember that from the day that the deposit's paid, the deposit needs to be invested in an interest-bearing account. And of course, then once that has happened, then the tenant, this would be step 4, so the tenant can then occupy the unit. All right, so I know that this is quite small. I had a few problems just manipulating this table. So I've split the table up again. As I say, I know that it is quite small for you to see all of the text. So billing the tenant, step 1 would be to calculate your monthly rental and related charges. So from your perspective, obviously, as the social housing institution, you would want to know what your financial viability is as an institution. So if you look at this explanation that I've given you on the right-hand side, what you would want to do to keep track of all your expenses is that you would add all the monthly expenditure. So what are all of your expenses, including your loan repayment costs? And guys, it's suggested that you include a provision for bad debt. So you can see the suggestion is 7% of billing and 2% for vacancy. So don't assume that you are going to be fully occupied all the time. So if you are doing your financial feasibility on the basis of 100% occupancy, you could land up with a very big shock. So you need to know that you will have bad debts and you will have vacancies where you're not getting rental. Step 2, calculate once-off charges. So, for example, if there are repairs and maintenance that need to be undertaken that the tenant is responsible for, perhaps they've been negligent with something, so they then need to pay that cost. You would need to then bill them for that one-off cost. Step 3, prepare invoices and statements. So you would obviously do the paperwork in order to bill the tenant. Step 4, check the statements for accuracy. And then step 5, print and deliver the statements. Either you would do that by hand or via things like email. Step 6, you would confirm that the statements have been delivered or returned, so that the tenant has actually received the statements. Step 7, you would want to initiate a debit order or a stop order so that you can get automatic payment on a monthly basis. So you would really want that from the tenant, is that the tenant needs to sign a debit order so that every month the rental is paid timeously on the 1st of the month. Step 8, if you cannot get a debit order, I mean, you might find that, let's say a tenant, for example, doesn't have a bank account, and John mentioned that the issue earlier of having alternatives for tenants, so that you're not prescriptive and that you tell the tenant this is the only way that it can work. So you need to have some alternatives. So what other collection methods would be suitable? And then, of course, step 9 is to record all of your payments. You'll obviously have a finance department that will do this for you. Your finance department would then also have on a monthly basis some kind of tenancy schedule, and on the tenancy schedule they would then be able to show who's paid and what money is still outstanding so that it can be addressed. So you would then find that your finance department might then issue the letters that need to go to the tenants that haven't paid rent and are in arrears. And then what you would do is send the letters to site, and the property manager or the supervisor or caretaker would then deliver those letters to the tenants that are in arrears. Step 10, so very important that you get tenants to put the correct references. You don't want to have a situation where a tenant pays an amount, they don't put the correct reference, it's not picked up on the bank statement because people don't know what it's for, and then the tenant is being shown as in arrears. And the tenant then gets all upset because they've paid the money, you now telling them that they're in arrears, and you now want to take action against them. Step 11, your debtors age analysis. So this would be to show what tenants are owing what money and over what period of time. So you hopefully not having anybody that's in the 120 days and above. Again, you want to address the issue of arrears as soon as possible. So here I've spoken about the issue of arrears management and, and what you need to do. So you can see the first letter of demand. So again, as I say, on the 3rd of the month, issue that letter. Don't wait for it to happen. Second letter of demand, okay, that would be perhaps on the 5th of the month, and you then want to be off to the Rental Housing Tribunal. Guys, also, I think the last thing that I want to say about this, and please, if you read the article that I've put right at the end of your manual, sometimes if the tenant's prepared to vacate and they're in arrears with, say, 2 or 3 months rental, sometimes it's more cost effective and it's a better business decision to make, to take the view that you're going to write off the arrears instead of spending money going to attorneys and trying to chase the arrears and incurring the costs of following the legal process, spending thousands or tens of thousands with an attorney to try and recover 3 months rental. So it might actually be better for you to say, the tenant's vacated, you've got the premises back, you can relet the premises. Yes, we are owed 10 or 12 or 15,000 Rand in arrear rental, but it might be better to actually write off the 10 or 12,000 Rand that you owed in arrear rental than to go and spend 50, 60, 70,000 Rand in legal fees to try and recover the arrears that are owed. All right, any questions that you want to ask? I thought we would actually have some questions with the Rental Housing Act. I'm surprised we haven't had any. Johannes says, fine. Now, Carisha, are you feeling a bit better that the landlord's got some protection in terms of the Rental Housing Act?
Yes, thank you very much.
At least I was able to give you some good news.
Yes, it helped a lot. Thank you.
Yeah. John, anything that you want to add about arrears collection, the Rental Housing Tribunal?
Well, no, not per se, but just to say, remember, I also mentioned that all the institutions or social housing landlords that are reporting to the SHRA on quarterly basis have to report against certain set benchmarks.
Yes.
The first being around vacancy rate. I mean, there's, I think, according to the set benchmarks, that you should not sit with stock of more than 2% in terms of vacancy and occupation. So that is one, I think, that is tracked on quarterly basis, and I guess it speaks to the exit processes that you've just taken us through, to say the need for the managing agent to re-tenant the unit as soon as, because a vacant unit is a loss of rental revenue. It's as simple as that. But also just, I mean, one of the second of the 5 benchmarks that is tracked is really around the very revenue collection. And we've spoken at length about that. I think there is also in the reporting, SHRA would want to know, in terms of what you call write-off of bad debts. I think it's somewhere in the reporting tool where institutions needs to report on, let's say, last 30 days, 60 days, and 120 days of bad debts or areas that have been written off as well. So those are some of the things that are inherent or embedded in the reporting tool that the SHRA uses to track performance of the sector and the institutions.
Yeah. And John, obviously the collection of rental is the lifeblood of the scheme.
Yep.
No other questions?
I think it's an indication that it's all been clear and well received.
Well, I hope so. John, I've put my email address into the chat box. If anybody's got any queries about what we've done over the last couple of days, I'm happy to respond to them.
Yeah.
So, guys, you can see you've got my contact details there.
Yeah.
All right. Well, so John, I mean, that brings me to the end of what I need to cover. So I don't know if you want to have a few closing remarks. I just want to say thank you to everybody for staying with us for 2 days. The fact that you have been with us for 2 days, I hope, is a good and clear indication of the value of attending the session yesterday and today. Also, the point I just want to re-emphasize, the point that I made earlier, is that please make sure that before you run headlong into social housing, you've attended the sessions dealing with accreditation. You are very clear about the accreditation process and how it works. You are very clear about SHRA's requirements and what they expect of you, and that you have all your ducks in a row, so that you understand exactly what it is that you need to do and what's expected of you.
Well, yeah, I think then this then nicely brings us to the end of the last 2 days, and just to say thank you to everyone who stayed with the course. I hope it has, to a certain extent, brought to light a whole lot of things that might have perhaps been obscurity. We are having a rerun, in fact, of the same topic, I think, Graham, somewhere in October.
Yes.
So if there is still an interest in you and you say this, I want to still probe some more, you're welcome to rejoin us in the October session. I think the dates are already up on the website. As I indicated, while I'm still on the training schedule, we will be updating that with a few other topics coming through and the dates thereof. Introduction, I think Introduction to Social Housing is the best one for everyone to attend. I saw even in the engagement this last 2 days that some of this would have been best be addressed in the Introduction to Social Housing session. Project packaging is another one, very, very interesting one. And if you have your professional teams, be architecture, be it quantity surveyors, and all those people that are involved with the technical side of the developments, also invite them to join in that session. Those dates will be put up as soon as we've cleaned up our stuff internally. I thought maybe just as a concluding thing, give you a quick rundown in terms of the support grants. I would have not done my job if I left this session without indicating that besides the CCG that we have at length spoken about, which is that money that you get to develop the houses, there is that pot of money where SHRA facilitates the development of the sector or the support function of the sector. And I just want to give you a quick rundown. So in there's about 5 types of grants, support grants that people can apply for. And I say people because there's specific criteria for eligibility as to who qualifies or who can apply for. The first one is the pre-accreditation grant. There's about 200,000 an applicant can apply for. And I say apply for in a sense that it would not necessarily be 200,000 that is paid as cash or dispersed as cash to you as an applicant or a grant recipient, but it helps you to access professional services as pertaining to your accreditation. So if you are here and saying you need to get accredited as a social housing institution, there is this pot of money that you can access to have the SHRA assist you with professionals or consultants that then would help you to package a successful SHI accreditation. As I say, it's about 200,000 that one can apply for. Quickly though, just before everyone sends an email applying for that one, we do want to see that you have at least taken effort to engage that application process independently first, because what that does, it then spits out that first application or attempt, it spits out a certain assessor's report, which becomes the basis for which we are able to then go and motivate for further support if in the first attempt you were not successful with the application. So that's the first grant. It's called pre-accreditation grant. And to these 5 grants, by the way, there is a summary document that I will send you that talks to these types of grants and how do you apply for them. The second one, quite quickly, and I'll be taking, I see your hands, but let me just quickly go through the last 4. The second one is the project feasibility grant. Now, with the project feasibility grant, we are saying we are here to support projects that have been registered in our register of projects, of potential projects. And this money is there to, again, enable you as a project owner or an applicant to access professional services around the feasibility, so that that application or that project application can be prepared to the point of readiness. Because part of the decision to award the CCG amount has to be based on whether the project is proving viable, both from the technical but also from the financial viability side of things. So this money is about 750,000 a project or an applicant can apply for. It would be there. It's there to essentially help you to plug on holes or gaps that are of short to medium term. An example would be you have a project and you need concept designs done, or you have a project, it's a brownfield or an existing building, you need structural integrity assessment done on it, or a traffic impact assessment, or a combination of these things and more. That pot of money called the project feasibility grant is there for that reason. But the bottom line is that the project must first be registered in the system, and on that basis, we're able to then see whether the project is or warrants the support. The third is the one that I've spoken about, the Staff Gear Up grant. If you were here yesterday, you would remember that this is the grant about of R500,000 to assist you with those initial staff costs. When you are taking on your first project, and that point you need to have a certain layer of operational staff in place. Your leasing people, your credit control people, your facility management people, and so forth. So SHRA or government has set up a fund to support you with those initial staffing costs, because it comes from a basis that at that point of taking on new stock, you do not have a cent in revenue collection. So for a period of, let's say, 5-6 months, and even longer, depending on how you've projected it, you would then be receiving cash injection to pay and offset those initial staff costs. The fourth grant, colleagues, that we also administer is one we call Remedial Action Grant. Now, this is on assumption that you are now have stock under management. These are 100 units or whatever number it is, and you are now starting to report on a quarterly basis. And in the event that we see that you are struggling with certain performance benchmarks, in fact, there are about 5 performance benchmarks that we track on regular basis quarterly. 1 being around vacancy, how you're doing in that regard. 2 being rent collection. 3 being your operating cost, and so forth. So if we are picking up that you are not performing at par with the sector in terms of those benchmarks, we're able to then deploy resources from the Remedial Action Grant money to assist you in remedying those performance issues. The last one is the General Capacitation Building Grant, and it really pays for a whole lot of things, that including training, research work, social facilitation. Someone talked about if there are disturbances at a project and there's then a looming rent boycott and we need social facilitation expertise to come in and engage tenants and really try and turn around this thing. We're then able to use General Capacitation Grant as an example to intervene in that project or institution. So that's a quick rundown, and as I said, there is a document that speaks to a summary of these 5 grants that I also will make available. We are almost on the end tail, but I see there are 2 hands. Let's just perhaps allow you, Tammy and Vuyiswa, if you just unmute yourself to ask your questions or deposit a comment.
Hi, John and everyone. I just want to find out, can it be possible for one to give notice to the tenants to move out during the period of their contract for maintenance, like major maintenance on the property?
Just so I understand your question, are you saying as the landlord, you ask the tenant to move out for you to be able to perform certain maintenance activities?
Yeah.
I haven't heard of such a case, but I would think yes. And I don't know. Perhaps it's something that a lease agreement can be used to provide that kind of a clarity, to say in the event that you need to perform some capital maintenance program on the asset, it might be that you think you need tenants to be moved. I'm not sure. I haven't really come across such a case, even though yes, amongst other maintenance requirements, there is that expectation from the program, and in fact from the SHRA in terms of regulations rather, that you will perform as a landlord those capital maintenance activities once every 5 years, 10 years, replacing geysers, replacing gutters and things like that. It hasn't really resulted in people having to be moved out of the I'm just not sure how they manage it in instances such as that.
Yeah, I'm not sure. Thanks,
Hi,
others.
John.
Yes, Vuiso.
Thank you. Hi, John and colleagues. Mine is on the grants that you've just explained, especially the very first one of the SHI accreditation. We've always been, I think we're gonna be very soon, in a week's time, we're gonna be doing our last submission, but we are trying. It's very difficult, John. I don't want to lie. It's not easy when you're dealing with the public sector side, municipality and the province and whatever, especially when it comes to land availability. Because that OTP that is needed, it's very easy to get it from the private sector. However, if you are actually emerging as we are from the Imbokodo SHI NPO at this point in time, NPC, I mean, we are trying to get the land from government rather than the land from the private sector, because we are actually looking in the long term that we might be actually hit by the market related costs when it comes to the buildings and doing other things and the professional work and all those things. However, we've got a situation of a catch-22 situation whereby in the municipality, and especially because I'm coming from the Western Cape, they've got various restructured zones. However, they are saying that we need the license. They call it a license, which is the license you have to get an SHI accreditation prior offering you any land that is available. It's even worse. In some instances, they are very strict. They say, you know what, we go for tender. You're going to have to bid like other companies or like other bodies, which is, we know that then we're going to be bidding with the big boys that have always been in this game, but we will actually take the leap. But on the other side of leasing, the long-term lease that we're actually aiming for, and we're actually having a very high hope for again, it's we're again, I think in the past 2 weeks that we had a meeting with one of the departments that I can't mention here. They were also hit by one of their units that they're dealing with. They were saying, we need something written down, that is some sort of an accreditation whereby we can actually try to talk terms with regard to this. So I am saying that to get that 200,000, because we were stuck initially with the policies, because there's lots of policies that we dealt with, and we needed some professional people to assist us with. We tried our best to do this, and at least I like the fact that SHRA does appreciate that you've made an attempt to do so, and we're actually looking forward to say that, okay, let's get that grant, at least for us support in terms of getting a very tight up policies, very tight up business plan. Now you cannot finish a business plan without a land, because you've got to do all those projects and stuff like that. So how do we really go around that, guys? Because we really need that 200,000 to assist us in terms of the professional work.
Yeah. So the grant money would not assist in this case where you are struggling to at least get that project opportunity. I would though advise, that you don't close the possibility of entering into an OTP with a private sector. And I know now we're talking about something that we could deal with in the SHI accreditation training. But I would say, given that, you find yourself in a catch-22 situation, that do not close yourself off from the private sector opportunity, because what that does, when we have approved the funding for you, all we need is just a 3 months OTP for us to be able to do the modeling, right? Obviously, there must be appetite from the seller to give you that much long. Even better, they can give you a 6 months or so. Of course, with understanding that it's a first come, first serve basis. If there's someone with deep pocket who wants to buy the property, it is what it is. So I would, yeah, I mean, when you talk about Western Cape, I know they're very good with land release for social housing, but you're right, that's the catch there that they would want. In fact, it's not just in Western Cape. I know KZN as well has had a very robust land release program for social housing, and they were quite clear in terms of the first entry point for them to even look at you is you've got to have the certificate or that license. So yeah, we could have it much more deep dive into your case, but that essentially would be what I'd advise. Make contact with ourselves, with Zanele, who's the process owner. I think you've interacted with Zanele, given that you're saying you have already done this process.
Yes, we have. She's very helpful. I don't want to lie. Yes.
Yeah. Okay.
Okay.
All right.
You.
I see the last hand on the line is that of Exodus. Exodus, please unmute yourself. Exodus, can you hear us? In the absence of Exodus, okay. I just want to then say, please look out for a mail shot with a whole range of handouts from my side. It will be the guide. I've made a note that I need to send you the guide, the PowerPoint presentation. There was a lot of reference of the Social Housing Act, and different sections of the Act and the social housing regulations. So we'll include that. We spoke at length and the importance of the pre-tenancy training, and I know that there is something that was written up many years ago. If that is of assistance, we'll also try and include that in the thing. The FLISP program that we talked about and touched on a little, and I said I'll try and find more information. Remember, that is that first home ownership program that is administered as a grant by NHFC next door. So we have information on that. I saw a colleague responded earlier and gave me a link and things like that. So we'll make that available to you because it is one of the mitigating steps that you might need as a social housing landlord, particularly around the rent, this expectation of ownership. Graham, you said in the manual there is a Rental Housing Act, right? So there isn't any need for me to provide.
No, I haven't put the full act.
Oh, okay. So I'll include that.
I mean, John, it's a short act. I think it's only 14 sections, if I remember correctly.
Yeah. So I'll include that as well. And I think there must be something written up on rental housing tribunals as well. So I'll try and source that information. And so that's about 6 or 7 total documents that will be sent as part of the handouts. If we've dealt with everything. Oh, hi.
Hi, John. Hi, everybody. Hi, Graham. I'm really sorry to Exodus. Can you hear me, John?
Yes.
Okay. My reason of engaging is that I've heard the presentation, I've heard the grants, and thanks for the eye-opening process, which we have gained much, and we're still looking forward for other trainings in the near future. John, my question that I heard about the length, the process of you being accredited, as you were explaining to Vuyo. Mine, for example, my case, it's so unique, John. In our place, in a municipality where I'm dwelling, you remember the first program called Breaking New Grounds? There was a program of government within the human settlement. But in our case, in our municipality, we have a land that was rezoned, structured, serviced. Service means sewer, whatever you do, that tar roads.
Yeah,
and it was developed by the Mpumalanga Economic Growth Agency, MEGA, because I'm based in Mpumalanga, by the way. The place it is developed, it is there, and for 3-4 times there's been attempt by invaders who wanted to invade the land as informal dwellers or so forth. And how does one be assisted moving forward in terms of retaining that, because that is the land of the municipality developed by a parastatal of a government, which is the Mpumalanga Economic Growth Agency. But the land, it's locked. Nobody can unlock it. I mean, I'm talking of a development that was developed back in 2007, 2009, and it's still there, remaining there, retained there. Nothing is moving there. And how one go about maybe the channel, or maybe we can do it off record, engage on email or so forth, or engage.
Yeah, I think let's engage offline because it sounds like something that we might want to dig a bit dig a bit deep on
Yes.
Because what we unfortunately cannot do as a shrub, given that our limitation in terms of mandate, we can't be a referee and a player and a funder at the same time. So we can't drive you to release the land and assist you and facilitate you there and be the funder at the end of the day, and also still have to monitor your compliance and performance. So what of course we try and do as part of municipal support program that we do, as in fact in addition to the training that we have a municipal support, is to assist municipalities with land release program for social housing. And one of the things, I guess, would be for us to then ascertain which municipality are you talking about. Is this even in a structuring zone? But that's a discussion that we can have offline if that is okay with you, Exodus.
Noted. Yeah, point taken. Thank you.
Right. It's just something that has just come in from Nobile. Could we ask that with the summary of the grants list you are going to send us, can you please include examples of the stage in which application? Yeah, it will have those kind of thing to say who is eligible, what's the process of application, grant quantum that one can apply for, and the purpose of the grant itself. Where can we access PDF to retouch on what we are working on today? I'm not sure I'm understanding the question, Koketso. Do you mind just perhaps asking your question before we adjourn the session? Rem, can you see the question? I'm not
John, I think basically what's being asked is all the material that we've used, and I think you've mentioned it on numerous occasions, is that you'll send out the material.
Yeah. All right. Now, if that's then, I think we can close on that note, and just to thank again everyone and Graham for the last 2 days. There will obviously be other topics, and if you are registered for those, just look out for confirmations as we go along. Thank you, everyone. Thank you, and enjoy the rest of your afternoon. You have my email. If there's anything, please drop me an email. I usually try and respond to emails within a day or two. Thanks.
Thank you. Thank you, everyone.
Bye-bye.
Thank you so much, John and Graham.
Bye.
Thank you very much, guys. God bless.
Yes, thank you.
Thank you, gentlemen. Bye, everyone.
Thank you.
Bye.
Bye, everyone. Thank you.
Thank you, bye.
Thanks, bye.